Your Lordship may be permitted to mention a matter and mentioning upon notice. Your Lordship, a similar matter on the point of maintainability is being heard by the Honorable Coordinate Bench, and the Honorable Coordinate Bench had directed this matter to be listed before the Coordinate Bench, Your Lordship, on the previous occasion. I'm handing over the order, Your Lordship.
So why this matter is appearing before us?
Your Lordship has the determination to.
So how can a matter be directed to be listed in a court which does not have a determination?
No, Your Lordship, the matter has been directed to be listed before the Coordinate Bench, Your Lordship.
How?
Yes, by the order, if I may place the order, Your Lordship. The matter is being heard before the Coordinate Bench on the same point of maintainability, Your Lordship.
This is something a different matter.
A different matter.
So this is another matter.
Yes, Your Lordship.
So,
but it's on the same cause of action, Your Lordship, but the same respondents and the petitioners.
But the way you have said that, I was under a different impression that the matter which is listed before a bench having a determination is directed by another bench to be.
No, Your Lordship, it's on the same point of.
What I was wondering.
I apologize, Your Lordship.
Because it never happened. I have not seen since last 160 years any such order is passed.
Your Lordship.
We'll see to it. We don't know what is the cause of action there and what is the cause of action here. Unless we are satisfied that the cause of action are intertwined, we can't.
I'm obliged, Your Lordship.
Without or simply on the mentioning, we can't release the matter and then. Yes, call.
May I have your Lordship's kind leave to mention an application in connection with a FMAT, my lord.
FMAT what?
From an order of injunction
Which
in a
year?
suit for partition.
Which year?
24, my lord.
24, we don't have a determination. Order 41 stage is over?
No, my lord. Admission is left. That is
why application? Unless the admission is done, then say order 41, it will appear.
order 41, my lord. Order
why you say application?
My lord,
is an order 41.
My lord, with your Lordship's kind leave, my lord. My lord, yesterday, my lord, supplementary list, my lord, your Lordship's division bench, my lord, had taken up a matter, my lord, supplementary list, item number 2, which was there, my lord. When your Lordship was sitting with my lord Justice Hinmay Bhattacharya, my lord, at that point of time, my lord, the matter was kept today, my lord. Mr. Mahesh Jetmalani, my lord, was leading me. My lord, we have just come to learn, my lord, that a circular has been issued, my lord, before in the court of the Honorable Chief Justice, my lord, saying that these matters, my lord, would be taken up by the bench presided by your Lordship, my lord.
Yes.
My lord, if your Lordship, my lord, could fix a time, my lord, then we would, my lord, hear out this matter.
Then we'll have to talk to Justice Bhattacharya because this is not that bench.
My lord, it is, my lord, subject to correction, my lord. This is the notice, my lord, which we have presided by.
Sitting singly, I can't direct because both of us has to sit. I don't know whether Justice Bhattacharya, who is also a part of the another
Yes,
division
that
bench, will be available. So we have to consult, and the time we can. What has happened to that? That matter has been assigned.
My lord, that matter has been assigned to your Lordship, my lord. And my lord, notice has been issued saying that the matter would be taken up by your lord.
Go. I have no objection of taking up the matter at any point of time. Go and mention before Justice Bhattacharya.
I'm my lord.
If he agrees on a particular time,
my lord, I shall do that.
We don't.
But I'm so
just rush and go.
Your Lordship, may I be permitted to mention one matter? Your Lordship, the matter was heard and disposed of on 5th of November already. Now, the direction was that to file the WO to the injunction application in the trial court. I apologize, Your Lordship. The written objection to the injunction application of the plaintiffs within 2 weeks from the date of disposal of this matter. Now, Lordship, the order has not been, till date, has not been uploaded on the site.
Talking about, I can't. The order was dictated in the open court.
Lordship, but Lordship, to file that written objection to the injunction application within 2 weeks from the date of disposal of the matter, the difficulty is that the necessary compliance cannot be carried out, Your Lordship. The server copy is needed to be served upon the other side.
I do not know.
Lordship,
Lordship,
today I'm standing.
In a technology, I think the
Lordship, the server copy we needed from the
area, I would say the era. We have started our when there was no technology, and the open court, the order was passed and it is communicated through a covering letter.
Yes, for that
you go, it was dictated in the open court. You could
Lordship, but
Within 2 weeks, affirm and file it. Where is the difficulty in the trial court?
Lordship, the server copy is needed, Lordship.
Why? Where is the rule? Where is the law? Tell us that without the server copy, no application, no written objection can be filed. You can file it. Filing, there is no difficulty.
Lordship,
Why? You have not affirmed also.
no, it is not.
To-
The written objection to the injunction
I
application.
was there for a pretty long time. I know these kind of things. Even you could not affirm the as you called WO within 2 weeks.
No, Lordship, the only thing is it is already,
Why you did not affirm it? It's only for the filing.
it needs to be, it
For
needs to be.
affirmation only after the server copy is obtained. You
But-
must have prepared the written objection. You must have affirmed it. And then at the time of filing, I can understand. Why you did not affirm?
But Lordship, the only difficulty is on 5th, it was already heard and disposed of, but till
No,
date it has
madam,
not
but
been
2 weeks
like
time was
uploaded.
given, then why it was not done?
Lordship, it
And
was
today
being,
is the last day.
it was being awaited for that server.
Why?
copy.
Affirmation does not require anything. You could have prepared it, affirmed it, and then do it. Filing is a different thing. Affirmation is a different thing.
Very well, Lordship.
You wanted to take advantage of this kind of the technical problems. You should have affirmed it and then come before us that I have affirmed within the time, but I am unable to file. I can appreciate that. You have not prepared your written objection within the time. You have not affirmed it within a time. And then you are saying that the server copy is not available. Hey, we order a server copy, can find out from the IT department. It ought to have been.
Obliged, Lordship, much obliged.
Well, maybe permit.
One order 41, my lord, from City Civil Court, my lord.
For release, give.
No.
Well,
Yes, for release, give.
well, may I be permitted to mention, my lord, one matter, my lord, already it is appearing as item number 235 of the list today. My lord, the urgency is, my lord, superannuation in January, my lord, by the.
Where you were, sir, last week.
My lord, we have filed the appeal within time, my lord.
Sir, where you were when the entire list was called thrice in this month. Nobody responded. We have to rise early after calling all the matters and there was nobody to do the matter. And then as per your
missed, my lord, my
convenience,
lord.
you come and say that this
My
is the urgency.
My lord, kindly, any day,
Wanted.
any time, my lord, that suits your lordship, my lord, any date, my lord.
Every litigant is equal before the court. Sorry.
My lord,
Everybody is waiting for that.
my lord, we have already given a notice to the other side also, my lord, my lord.
Maybe,
Kindly,
sir.
my lord, any date that suits your lordship, my lord, kindly, my lord.
Simply because your client may have some resources to
Well,
engage
well,
you and
not
to
that,
make
my
this
lord.
matter. That does not mean
Well,
the others who does not have that resources.
My lord, not that, my lord, it was running in the list, my lord, we were following up, my lord.
Quality before the court is no difficulty. Every matter will be followed.
My lord, kindly, my lord,
Accused every member of the bar.
my lord,
I
still,
can't
my lord.
single out you because of your persuasive appearance, because of your pleasing personality. That does not mean
Well,
that I am.
not like that, my lord. We have some urgency, my lord. Otherwise, my lord.
I had also mentioned, my lord, we both of us are here, my lord. Kindly, my lord. My item number is 6364.
Will be called. Let us see. Yes.
With my lords, kindly may I be permitted to mention an old matter to be listed under the heading hearing, my lord. 2008 matters, my lord. First appeal.
May I permitted to mention to group 2 application.
May I have you lordship kindly mention one matter under the heading review application, lordship, for upgradation, one day.
Upgradation which.
My lord, I have some notice upon the, your lordship may please.
Sorry.
My lord,
We have
petition is,
refused the other members of the bar. Yes.
petition is senior citizen.
Madam, may I be permitted to mention an old matter, FAT 316 of 2009. The appeal is yet to be disposed.
Lordship.
And another one of 2024, it's a MAT appeal.
Lordship, may I have the liberty to mention one matter, Order 41, Rule 11, Your Lordship, for inclusion.
Lordship, may I have a kind leave to mention one matter for restoration for inclusion.
Which group 2 or what?
It's arising out of first appeal.
Of which year?
Your Lordship, in that case, I have to get my
FAT
instruction.
number of which year?
2004. 2004. Your Lordship, one more indulgence. One application under Order 41 Rule.
Not an application.
Pardon,
41 Rule 11 for admission.
Pardon.
My lord, kind leave to mention, my lord, my friend had, learned friend had mentioned the matter. Apologize, I'm mentioning again. My lord, I'm humbly praying if the matter could be kept under the heading to be mentioned, my lord. My lord, on the same cause of action on.
Unless we look at the file of both the matters, we cannot say that the cause of action are
My lord,
interchangeable with that one or infused.
my lord, on the point of maintainability, it has been referred and it is.
Sorry, let him decide. There will be a division bench judgment.
Yes, yes.
Coordinate bench. We will consider at the time.
Yes.
No difficult.
May I be permitted to mention a matter, my lord? It's an Order 41, Rule 11, City Civil Court.
It is over for release.
Great.
May be permitted to mention a first appeal matter for the year 2008 City Civil Court matter.
City court.
City.
Then why you are mentioning? Mention before the other release for.
What a release.
Yes.
That's my application. I'm the respondent to the second appeal, millet. My application for clarification, millet, is an order of confirmation against with the second. Otherwise, my execution code is adjourning the matter for since long, millet.
This is clarification.
That pendency, the order 41 rule 5 is there, millet. The pendency of this.
So it is already
there in the statute. My only thing is that
it is appearing in the list.
no, this is not appearing in the list.
Well,
Right, it was dismissed. They have restored and seeking adjournment before the execution court.
no, the order 41 stage, it was dismissed.
It was dismissed.
Then it was restored.
It was restored.
You are for?
Respondent.
Have you ever appeared before Justice N.K. Mitra? Give.
I have no right to audience.
You will face the same consequences. You used to sit in this.
No, only difficult.
Same thing you will face. Don't worry.
What is the judgment that?
Right to.
You should understand that what he used to do when a respondent mentions for order 41.
Difficult I'm facing.
অনিন্দ মিত্র রায় করতে চেয়েছিল হিয়ারিং রাইট অফ অডিয়েন্স বিমল চ্যাটার্জি একটা আছে বিমল চ্যাটার্জি স্যারের দু নম্বর কোর্টে
To give them the same fate. Choice is yours.
May I renew my prayer, Malad, for upgradation? Malad, kindly hear me, Malad. Malad, at least 60 crores been Malad, invested, and Malad, RERA authority has Malad given a stay on my project, Malad. They have issued the registration, and thereafter, Malad, unilaterally.
Malad, as a last chance, Malad.
Your voice.
Malad, as a last chance, Malad. Malad, this.
Yes, what is?
Malad, I'm the respondent, Malad, in this appeal. Malad.
Sir, I tell you very frankly, I have refused every member of the court. Every member of the court. If I allow your prayer, I think I will not have a good sleep in the night. That I have discriminated the other members of the, maybe a junior most. He will have that sense that since the seniors like you peoples are appearing, and then the bench has accepted. I was a junior, my prayer was not accepted. I do not want to have that impression in there. Please do not embarrass me.
Sure.
With folded hand, I am saying.
ঠিক আছে ও এর জন্য করেছে মানে contempt matter in 2000 আমার পোস্ট জমা দেয়নি সেই জন্য the losses kindly accommodate
group 2
any day subject to losses
passed by the judges who are not there.
Single bench by your lords.
Oh, single bench.
Single bench by your lords. Any day subject to losses.
Evaluate sir, item number 1. Malad, at my instance, this matter has come up to be mentioned. Malad, I am the respondent in two analogous appeal, Malad. Malad, one, Malad, I am the land. One, my suit is for eviction, Malad, that has been decreed, and the partition suit has been dismissed. From where, Malad, two appeals has been preferred. Now, my lord, by the appellant. Now, my lord, both the appeals were dismissed for default. It was my fault, my lord. On last occasion, they filed a restoration application and a section 5 application. Copies till date not served. Before Justice Mantha, division bench, my lord, the matter came up, my lord, on 4th of October. I considered, because, my lord, an assurance was given by the other side, my lord, be that as it may, that they will be doing the hearing of the appeal. My lord, and the order was recorded to that extent also on the last occasion. Now, my lord, now it has been restored, condoning the delay. Both the appeals, my lord, though applications has not been served to me till date. I have mentioned them in later while mentioning it before your lordship. Now, my lord, the difficult, I'm in a hurry, my lord, because I'm the landlord, my lord. My lord, the lower court records has gone before the court below.
Expression lower court.
My lord, the trial court, well, I stand corrected, my lord. My tender apology. My lord, the trial court records have gone down. My lord, kindly allow me to put in the special messenger cause so that, my lord, I can bring the trial court records, my lord, and the appeal. Prepared.
Where is the school authority? Has it?
Yes, my lord. I am appearing on behalf of the school, my lord. Yes, my lord. Yesterday,
The school also.
state I am not in this matter. I am not state, my lord. My lord.
For the state also is appeared for the.
All the matters, my lord, I appeared before your lordship on behalf of state, my lord. Today is the first time I have.
Have not given an objection.
My lord,
An objection
my lord.
for such a long time. Why? Why there was a delay? Who will?
My lord, I want to show before your lordship some documents. It shows that school is nowhere responsible. My lord, kindly have a look to my some documents, my lord.
So you did not issue a no liability certificate this time. So what can be done? When you attend first in order to assess.
My lord, I want.
When you attend superintendent.
I retired on 30th November 2020.
2020. 20.
Pension payment order was issued.
Yes. Now you
24 December.
now the formal request for handing over the bunch of keys of the school almirah as well as the submission of papers and documents of the school.
My lord, I want.
That was done. There was a dispute. They have said that you have not given. I say I have given. Ultimately, matters sorted out. Madam, that no disciplinary proceeding was initiated. Nothing was there. So when I moved before this court, madam, they came before the court and said we have issued the liability certificate.
My lord.
This was the reason. Now, madam, the PO was issued on 24th December 2020. And in the date,
PO was issued on
24th December 2020. 24th
24
December 2020.
Yes.
And madam, the order was passed On 9th October 2023, I received the pension November 23.
November 23.
3 years delay.
Lord, I want to read one paragraph of this application, my lord, page number 20, my lord.
Want to say
Their application.
let him file an evidence.
My lord, I want to read, my lord, first this paragraph, their petition, my lord, paragraph number 4, my lord, page 20, my lord.
Which application?
Lord,
The can 1 or can 2?
it is starts from
Can 2 is the continuation. Anyhow, can 1 paragraph.
no, I am reading from the writ petition, page number 20, my lord.
Petition.
Yes, it is annexed.
20.
Yes, my lord. Paragraph 4, my lord. That the petitioner, while working in the capacity of the headmistress of the said school, my lord, done the audit of the school from year to year, lastly up to 2013. My lord, she worked up to, my lord, 30th November 20. My lord, audit was done up to 2013, my lord. 13 to 19, there is no audit. It is pending, my lord. And when the petitioner retired from her post, she handed over, it is their contention, but she handed over the charges to the teacher in charge, who is an approved assistant teacher of the said school, and nothing remains with petitioner, and there is no occasion for further financial calculation and or documentation on the part of the petitioner. It is stated here that while the petitioner was in service, he handed over papers and documents of the school to the present teacher in charge, and also tried to hand over keys of the almirahs of the headmistress office. But yes, my lord.
38.
My lord, before that, my lord, after retirement, the present headmistress, my lord, joined on 22nd September 2021.
Their letter.
Yes, we have.
You have said
No,
that-
this is my letter. I am
asking Mr. Bari. Their letter. Where is your letter of handing over?
Page 39. Page 39. Which is also standing.
So till 8th November it was not given.
Now, my lord, the DI took steps for resolve the issue. Your lordship, kindly have a look at the decision of the DI.
This is my first letter after my joining, my lord.
Page 41.
My lord, I wrote at least
Even prior to the November was done on July.
Yes, July.
Then
2021.
Then what happened on July?
Hearing was held at the chamber of such and such. After a period of time, he revealed no liability certificate still not issued when notified. Hence, you are requested to submit a follow-up action. Taken report in the office in respect of the hearing held such and such.
No, where is that? Then what happened? 16th.
Then, my lord, the lordship 8th November 2021. The lordship can be have
No, you said that it is lying with you. You can.
But you have always to accept the same.
Yes,
It's 43 if you look at
I
clearly.
have seen that.
Now, my lord, that was not given. I moved before the court. Then, my lord, the matter was pending. And what is the submission made by the London advocate appears for the school authority, page 59, order of the bottom portion. The delay in disbursement of the said retirement benefit has been caused due to non-issuance of the no liability certificate from the school authority. If Shomen Bandyopadhyay, advocate for the school authority, files the written instruction that on October 7, 23, received by him from the present headmistress of the school, the said institute does not indicate any objection with regard to issuance of the required no liability certificate. Let the same instruction be kept with record.
So nothing was found against you.
Yes, nothing.
My lord, I am showing my documents, my lord. My lord, which I have handed over, my lord.
Madam, you have already filed a written instruction of October 7, 2020.
My lord, all the documents which I have handed over, my lord, kindly have a look to my documents, my lord.
Whether these documents were given on
The Honorable
October 7, 2023.
No. My lord, it starts from, my lord, on 22nd September 2021, my lord, the new headmistress joined the school, and thereafter, my lord.
Probably you have not read the brief.
My lord,
What I am asking you, you are unable to comprehend it. Please look at the impugned order.
Yes.
First page, last paragraph. Please read that. Your counterpart,
yes,
Mr. Sumin Bandyopadhyay, a learned advocate for the school authority,
yes,
files a written instruction of October 7, 2023, received by him from the present headmistress of the school.
Yes.
Said instruction does not indicate any objection with regard to issuance of the no liability certificate. I just wanted to know whether these documents which you are handing over was there in the written instruction or not there in the written instruction.
my lord,
Just wanted a simple answer.
Lord, in the trial court, I do not know which documents was relied on at that time, my lord.
It is you who appeared in the
Lord,
trial court.
yes, my lord.
And it is you who is appearing in the appellate court. You do not know what has
My
been
lord,
done.
yesterday night I have received the brief, my lord. I have received some documents. Give me some time so that I am.
We can't.
My lord,
Do you have any copy of the written instruction?
my lord,
We can't.
my lord.
What is this? Every time the new document will come.
No, not
to
new
the appellate
documents,
court.
my lord. All the documents, my lord, which I have relied before your lordship.
Sorry.
All the documents which was I have relied now, my lord. Kindly have a look, my lord. The school has known all the.
Sir,
My
if
lord,
we are directing the state to pay, you wanted an interest.
my
on
lord,
that.
my lord, kindly, my lord, kindly, my lord.
Then
My lord,
we are directing
my
the
lord.
DI to fix a responsibility.
Yes.
If the DI found that it is the school is at fault, then the DI will recover that amount from the school.
My lord,
If a DI or the relevant.
my lord, kindly, my lord, I want to.
And if the state does not find any fault on the part of the
Yes, no problem.
My lord, my lord, kindly have a look. My lord, give me, my lord, I want to file affidavit. My lord, all the documents which I am, my lord, kindly give me time. My lord, kindly, my lord.
whether you have a right to file a document which do not form part in the trial court's record.
My lord.
Can you rely for the first time in the appellate court?
My lord,
I'm asking you.
my lord, I'm.
Simple. Can you rely?
No, my lord.
No.
No, my lord.
So why will go into all those aspects?
Then, my lord, kindly one thing, my lord. After joining my lord, the headmistress as a headmistress, my lord, I wrote at least 3, 4, 5 letters. One for the.
These are not the part of the record.
Lord, she is not handing over the charge, all the documents, all the.
And no liability.
No,
has
my lord,
been
kindly have a look to
by you.
one trial court's order, my lord. Kindly, my lord. This was not shown, my learned senior friend, my lord, which I have annexed, my lord. Kindly have a look to learned court order on 26 June 2022 as page 8, my lord.
These are the part of the record we can look at.
Kindly, my lord. This is the order of this honorable single bench, my lord. Yes.
Which one?
My lord, page 8. The petitioner shall render all assistance and cooperation to the auditors in conducting their work as and when called for by them. After the order, my lord, thereafter she cooperate us. Before that, my lord, she did not cooperate with the school authority, and my lord, DI sent 2 persons to unlock the almiras and everything, my lord.
Thereafter, this thing has happened.
My lord.
Written instruction was given in 20.
Yes, my lord.
Clearly,
Only on 26 June. Thereafter, she cooperate with us, and thereafter, the kindly have a look to the.
Anyhow, if there is a delay, then nothing has found against her. There is not a embezzlement of any money, not of any kind liability. Then she is entitled to interest. My own judgment is staring at my face. And
My lord,
since the state has suffered, the state will take a responsibility of finding out who is at fault.
my lord, one more thing, my lord, kindly, my lord. The DI, my lord, DI's orders, my lord, kindly have a look. My lord, we have no fault. We wrote every.
Go and convince the DI.
My lord, we
The DI.
and a letter to the Commissioner of School Education and the administrator. Everywhere we wrote a letter. She did not hand over the charge. My lord, 2013 to 19, my lord.
The authority.
No audit was done in the school, my lord. Everything pending.
Again, that's why I know, because of the mental setup. You simply you appear for the state. Your mental setup is for the state. We are not imposing any cost on you now. We are imposing cost of this on the state. And only thing is the state is at liberty to find out if the school authorities are at fault.
My
Then
lord.
that realization can be done from a school authority.
My lord.
So if you are very confident that you are not at fault, why you are afraid?
My lord, kindly pass me. Sorry.
That is the mindset, because I asked this question for this purpose. Because you will fight for the state. The still the peak is why
I'm deeply grateful, my lord. I'm deeply
My lord, taken about 2 minutes. This
true. That is, yes, my lord. That is what I had mentioned, my lord, and your lordship had indicated. I'm deeply grateful.
I'm deeply.
Item number 7.
Item number 7, Your Lordship, on behalf of DPSC Malda, Your Lordship, we have just received the information about this case, Your Lordship. I'm praying for not today, Your Lordship. Some time is required to get the brief at least. Just today we have received the information.
Maybe on Monday, Lord.
Just একটা information.
Yes, yes. Rapid is in order. Section 5 allow.
We are in difficulty.
Your Lordship, just today
We cannot have.
from Your Lordship, there was no proper communication from the DPSC. No, Your Lordship, from the DPSC, Your Lordship, it was not communicated to us. Just today. Today, just in the morning, Your Lordship. Lordship. Definitely, Lordship.
Monday, my lord.
Monday. Much. Malda, Lordship.
It is same position. Yes. Yes, yes. No, we are afraid because 7 years going on in Chief Justice. Yes, yes. হিমতটা বোঝার চেষ্টা করি না
Much also. Thank you, sir.
This item also we are in afraid that whether it will come.
You should not understand what judge can understand what I mean.
That's why you judge.
Ask him what I mean.
Yes.
Item number 8.
My lord, 8, my lord, I am Arjun Roy Mukherjee is appearing in this matter, my lord. My lord, kindly thought pass over, my lord. My lord, please, that case. Yes. No, my lord, only not today. Yes, my lord. No, my lord. Yes, yes, yes. Yes, yes. Yes, 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 my lord. Yes, yes. Grateful, my lord.
আমরা মনে রাখবো 9.
My lord, may I address on behalf of the appellant? Yesterday, the hearing got yes. The second half we were waiting, but couldn't be taken up. Anyway,
Lordship was at page 54.
yes,
Last
yes,
item.
yes. My learned friend is harping on page 54 because the observation apparently.
No, I'm not harping. I'm not harping.
Yes.
Lordship.
But there are subsequent events also which are required to be taken into account. Only then the correct meaning of what was stated in page 54 will become clear. May I first read the relevant part of 54, which is creating the problem? Yes, yes. This is an order dated Lord, may I place it? 31st March 2023. Yes. Here it is stated that if it further appears that the total number of successful candidates pursuant to the re-evaluation has now come to 73. This re-evaluation was of the TET papers. The marks increased and they became qualified TET candidates. Now, since they became qualified, they were now permitted to continue in the selection process. Then the court says
There was a
steps may be taken
Lordship wanted to know whether total number of writ petition was 73, total was 83.
Yes.
Yesterday I did not.
Steps may be taken by the Chairman School Service Commission to process their applications. So now their applications for the selection will be processed till the recommendation stage. This, in my respectful submission, does not mean that everyone will be recommended, because we are now processing the applications TET onwards. That will include interviews. So now they went for interviews, their marks were added, and then the question of them being eligible for recommendation comes. After this, we were directed by the court to explain what happened to these 73 candidates in an affidavit. That affidavit is annexed. Kindly come to page 74. This is after the judgment. After the judgment, we are now analyzing what happened to the 73 candidates. Your Lordships will kindly see page 76, paragraph 6, subparagraph A. 6 contempt applications were heard together and disposed of by the Honorable Court by an order dated 8/5/2023. On being satisfied with regard to the compliance of the solemn order passed by the Honorable Court on 29/6/2022. In the said order dated 29/6/2022, the Honorable Court had been pleased to direct the Commission to consider the case of the writ petitioners' candidates and to give them consequential benefits. Accordingly, a total number of 83 candidates were considered, out of which 73 became entitled to get the consequential benefit and called for personality test. So initially there were 83 petitioners. We added, no, after re-examination, we added the marks. 73 now went for 73. 4 petitioners were absent and 69 appeared in the personality test. Finally, 60 petitioners were recommended out of the 69, as the remaining 9 did not come under the zone of consideration for recommendation. The writ petitioner is one of such candidates, one of the 9. As the remaining 9 did not come, while disposing the said contempt applications, the Honorable Court was also pleased to observe that in case any individual cause of action, etc., separate, independent, fresh writ petitions are to be filed. Now kindly see the order under appeal. That is page 83 of the stay petition. Now the petitioner came up in the contempt, and this is what was observed by the court. Page 83, the court finds that the petitioner qualified in the personality test, but was left out for shortage of marks. Admittedly, the petitioner has 5 marks lower than the last qualified candidate in the state level selection test 2011. Which was conducted in the year 20. So it is an admitted position. The petitioner knows that why he was not recommended. It is an admitted position. In the presence of the advocates, this matter was passed. The court holds that admittedly he is below the last recommended candidate. 5 marks lower. It's not a small marks. But why did the court then direct? Why did the court then direct to recommend him? That was purely on a sympathetical ground, that since due to the passage of time, he is now overaged. If he wants to sit in some subsequent selection process, he will not get the chance. So this round he misses it. The next round he is overaged. So the court said, take a sympathetic stand. The court has made a request, not a mandatory direction, but it is obviously to be. And the view of the court is that you send him to some remote school where nobody wants to go. There are so many schools without teachers just because of the location. Court said, send him there. Neither of the two can we do. Neither can we recommend him if he is below the cutoff, and we cannot send him like a punishment to some vague school where nobody goes in a remote village. The court goes on to say that therefore makes the petitioner has now crossed the age of participation in future recruitment. This is why we had to come up in appeal, or else this was a very gentle order. It was just a request. The court therefore makes an earnest request to the chairman that the West Bengal Central School Service Commission to consider the case of the petitioner sympathetically and without creating any precedent whatsoever, and to appoint the petitioner in any zone in the state of West Bengal. There are zones and schools in the state where the teachers normally do not wish to go. I cannot send him in such a manner. Firstly, I cannot send him at all because he did not come within the zone of consideration. And secondly, I cannot treat him as though I am punishing him and send him to a school where, if I am directed to give him a recommendation, then naturally that should be as per the available schools. I cannot select his school and send him to the middle of nowhere. The rule permits counseling. Firstly, the rule does not allow me to recommend him if he is below. No, that is because he was not within the zone. He was dropped. My lord, courts request that affidavit we can give because yes, I understand. Let me take instruction. Because it is difficult to verify, even if it is. No, there are cases. But below cutoff, court has directed, in my memory, possibly not, but in many cases where we have opposed, but the court has turned down, whatever reason we have. Because the request of the court also, we always, your lordships know that the request is to be accepted as a direction. We never exert our own opinion over the court. Only this candidate was directed. Because the candidate had become overage, that reason also the court has given. But without going through a selection process, without being successful, many other candidates maybe have also become overaged during this since 2012. Does that debar us from trying to make things better? Why? I ask myself. We always
What time?
try to make things I leave it to you, your lordships, because I've pointed out that he was below the cutoff. After interview, we gave him all the consequential benefits. After that, directing appointment.
Next matter is you'll get it. But my learned friend was, we are having, can I say it?
Let it be between us.
Okay, fine. I won't. He said something, but I won't. Before I say anything on that, my lord, in usual situations, the courts really do not extend the sympathy. I would only say there are 5 things which court has not elaborated. Court has only used 2 words: special facts and circumstances, and after considering my exception. The 5 things my learned friend is referring to, that my number is below a particular zone. There is no cutoff. That's, I think he will correct himself. There is no such cutoff. Now, 2016 onwards, there is no zone at all. This entire litigation was continuing for last more than 11 years. Had it been by the zone itself, personality test would have been taken by the Western zone. But my personality test has been taken by the Central Commission. And the true fact, possibly, not possibly, because they are so confident about it, because the 5 marks was personality test, 60 was on subject paper. They lost the paper, so they made an averaging of the marks. If lordship enters into on evidence everything, they will say the truth. But what the court tried to do is that, because of that incorrectness, some persons who are in service, possibly they have to be thrown out. The court did not do so. So from one angle, it looks like as if it is, yes, 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 subject.
That I will have to take the
Yes,
instruction.
okay. Yes, yes. Yes.
The reassessment was done of the TET. Yes.
No, answer script of the subject paper. That's the main mark, 60 marks. Kindly. Yes. Yes.
That was the
that is regarding the TET. What
that
they
was
did,
the TET. That was
they recruitment main process is for subject paper 60 marks, personality test. Yes, yes.
10 and 12.
The last occasion, your lordships, lordship had called upon the board to produce the panel and
Panel. That OBCA panel, your lordship.
yes.
My lord, I have bought it, but my lord, I have one my lord, reservation in regard to the expansion of the scope of the writ petition. If your lordships look at the scope of the writ petition, he's only asking for declaration of. That's what I'm saying. OBCB হিসেবে আপনার ক্লাস তাই তো? এটা কি এভাবে দিচ্ছিস কেন? সোজা কর। একটাই কপি। My lord, kindly excuse me this as I sent by the board, my lord. One copy. You also look into it, then I will make my submission. কোনটা এটা? এটা কি? এটা তাহলে লুজ কেন এরকম? পেনিল। আচ্ছা। আচ্ছা ঠিক আছে। আচ্ছা is the OBCB. OBCB.
Lordship is asking for OBCA possibly.
OBC doesn't belong to it. It belongs to OBCB, if I'm not wrong.
Lordship on the last occasion was inquiring regarding OBCA because that is given for the economic backwardness.
তুই একসাথে আগে আস্তে আস্তে বল 3 জিনিস পাবে না ট্রেনিং আফসার অ্যাসেসমেন্ট পেপার বুক করে
Escobar Victoria.
All right. May I make little submissions on this? OBCA. Both OBCA. Whatever is there, I tell you losses so far the petition. No. আরেকটা কপিও নেই
একটাই তো ভর্তি
তুই ফটোকপি করবি তো may I make one humble submission? OBC, I got it.
Now, this is in regard to first I submitted with your lordships the petitioner's assessment, the red petition. Now, I tell you lordships, the petitioner was ineligible for the recruitment process. I tell you lordships why? They were untrained. Untrained, I tell you, this is a 2020 recruitment process. I just narrate it before lordships. Board allowed them. That was questioned before this court. This division bench of this court allowed boards act on the basis allowing them by a notification was quashed by the division bench, saying this is contrary to law because they got the training qualification after the last date of the inviting applications. That judgment I have, your lordships. Well, I tell you, lordships, none of those candidates have been appointed because they went before the Supreme Court. Initially, the Supreme Court stated that
number 7 to 11, where is the single number 1 to 6?
এটা কি ওবিসি বি আর ওবিসি এ
ওবিসি এও এখানে আছে
এরকম একটা লুজ কেন
এই ক্যাটাগরি ওয়াইজ তো
মানে these are category wise OBC B panel. I'm giving you losses OBC A also. That's true. I tell you losses. Your losses will not 1 to 6. This is the
First column, look at the serial number.
7. These have been this have been given to your lordships. If I am not wrong, this
Number 1 to 6.
that we do not have to do. I tell you lordships why. The panel I have given to your lordships. This because this sheet contains the name and particulars of the petitioner. That's why I've given you lordships.
How much marks they got?
No, your losses will be getting details in it. I'm giving you losses. This is the broad sheet I've given you losses. Your losses will be getting. Well, your losses, well, that's not your losses, it's continuous.
না 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 আমি বলছি এটা এই দেখুন এখানে 1 হচ্ছে শিডিউল কাস্ট এখানে হচ্ছে শিডিউল কাস্ট জেনারেল
General also, the schedule caste also, why you hide 1 to 6?
না না
This is not hiding, my lord. Even after 11, your losses will be getting more, probably.
That we wanted to know 1 to 6.
আমি জানি না এগুলো কিভাবে দিচ্ছিস
সব ওবিসি বি প্যানেল
বলে এক একটা গ্রুপ ক্যাটাগরি
ওবিসি বি প্যানেল সব
What you have given?
OBC B panel.
OBC B panel, your losses category wise. Both are there, your losses.
OBC A was.
OBC B small and OBC B.
That's category wise different, your losses. OBC B different category.
OBC B.
OBC B, even within OBC B, your losses, there are categories.
What category?
Your losses, suppose your losses will getting physically handicapped. I'm giving an example. Physically handicapped will be different category.
Have you subcategorized the ECB number of suppose ECB has a total number of 100. That's how you are categorizing.
That's according to the rules. That's the loss. That's
Just with the construction.
rules আছে তোদের কারোর কাছে না কারোর কাছেই রুলস রুলস চেক আছে দোকান তাহলে just your loss. কাপে রুলস এখানে কারোর কাছে নেই রুলস প্রচুর মামলা একটা কাজ এই এটা ওবিসি
Caste. Then see a caste. But it would be a category. Caste is different.
caste is different. But they, I tell you, Losses, they have prepared according to OBCA. No, your losses will find
One category of OBCB. If you are saying OBCA category, there is 100 posts according to the merit level.
no, I tell you, losses, I don't know which. Suppose your loss is ex-serviceman. This is a category.
Then you have to show that everything, that whether it's a X category, then it's a different
Malad, I take your losses. Your losses take.
different category.
That's your losses. The ex-serviceman.
CA, then why you have included? That
I could.
you have not demarcated. The OBCA. Because that is a different category. Ex-serviceman category is a different category. In the ex-serviceman, you can say OBCA, OBCD. Scheduled caste, scheduled tribe. I do not know whether you can make a distinction.
Scheduled caste, scheduled tribe are different.
I'm talking about the different categories. OBC does not mean that is a other backward class. By understood.
That's your loss.
So how is to be assessed that he belongs to another backward class? In a backward class, there will be a different caste. What we think a backward class into a C. If we are backward class because of the economic disparity, backward class for this, if say no, this cannot be categorized, then everybody who is a backward class will come in one category, irrespective of their class, creed, or religion. I just wanted to understand. I am not very aware of this.
Then your losses take it at another day. Let me.
You have said PCA caste. PCA caste cannot be done.
Malad, I take your losses. Malad, I thought it, Malad, whether I may be. Malad, I tell your losses. Malad, I may be wrong, your losses. I thought your losses wanted the petitioner's details. I can বুঝেছি না এটা বুঝিনি দেখুন প্রথমে দুটো এক্স সার্ভিসম্যান তারপর 15 টাকা এক্স এভাবে রাখা কেন একই জায়গায় ভালো রাখা তো দুজন তো আলাদা No, if I may be wrong, Malad. As I got the Malad impression that your losses wanted the petitioner's details. How are we concerned? Then, Malad, with all respect, Malad, this is not the scope. I will satisfy to the yield. I will satisfy to the yield. That's not the point. No, 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 no. I tell you, that's I'm telling you, lordships. When the advertisement was published in 2020, if I'm not correct, Malad, I give the date, 2022, there is a cut-off date that by this, Malad, one has to file the applications. Malad, with the notification, this is the rule. Board on its own issued a notification, whosoever undergoing or pursuing the course of DLET, training qualification. So that's why they were permitted. They are allowing. That clause is contrary to rule. No.
And then was can set aside that clause.
So therefore, their application gone. Some of the candidates went before the Supreme Court. Malad, the Supreme Court initially stayed. Then, having heard the board, Supreme Court said, keeping aside those candidates who filed on the basis of this clause, which was deleted by the High Court, Supreme Court allowed the board to publish the panel and appointment. Accordingly, 9,000 and odd candidates have been appointed out of 11,000 or 12,000 declared vacancies. And so far, these 3,000 candidates, Supreme Court says, take their interview and give it to us. That's the order of the Supreme Court. So that's why their interview have been taken and given it to the Supreme Court. This is pending. But this is pending before the Supreme Court in respect of 3,000 odd vacancies. Whether now the question remains whether they are still eligible or not because of the division bench judgment. That has to be heard, and then their fate will be decided. Now, I tell you, Lordship, so far the board is concerned, my lord. Board, my lord, has nothing to do in this regard because rules have been framed by the government. We invited applications, petitioners participated as OBC. He never claiming that he's a transgender. He participated as OBC.
One sheet, you have said that one of the gender, you have written other. You have not said male or a female. No. Look at the gender color, what you have written.
Yes, sir.
Others.
Oh, probably he, during the interview in terms of the Supreme Court,
Fiction or assumption.
I tell you, Lord, it's other.
Said other, you were conscious that not clean.
Yeah, Malad, I tell you, Lordship, this is a state of 14th March 2024. This was done, Malad, after the entire process was over. When he, Malad, became.
This sheet to us to convey something. We can't.
I have nothing to hide.
I document as a whole, not in a piecemeal that you wanted to rely on this portion only and exclude the other portion. Do it. We are saying that you are aware.
Probably in the interview board, he claimed that I am a transgender. At best. But the application I can produce your lawsuits if you want that. He claimed OBCB. And he applied. Suppose Malada.
In the court, if there is no gender color, then somebody cannot find something else in a gender color. If there is a gender color, how she has.
Suppose the form was prepared according to the rules. Form was prepared according to.
Whether he or a she.
Well, probably he should be transgender. It has to be written. Now, the rules didn't permit that.
So we'll do in this case.
I don't know, son.
Yes, but it is a choice of the person concerned. In the affidavit, it says it's the son of.
No difference. He can be addressed as that.
He can be addressed as he. Now, our malad, we are circumscribed by the rules being a board. So, malad, our form didn't have any column which do not permit the rules. So that's why malad, it is male and female both.
Page 50 paper.
Malad, page 50 paper book, your losses will find is category OBCB in the paper. No, I am not real losses, only the form I am saying.
That I did not express so.
No, your losses is
You said that the application was not at the time of it was. I said whether the application contains the color of gender.
Yes, my lord, there was a call.
So no doubt about it.
Malad, so
About the gender.
Gender, he did not write anything.
Malad, he didn't write anything at all.
So the gender was blank.
Blank.
So because you must have written male or female.
No, it is
No, I'm
not.
not anything.
It was not recognized in the rule, lordship. So that's why she has not written anything here. It was not given the reservations and whatsoever, that recognition in the lordship, the notification, it was not there. She kept it there. No.
That's him.
That's not a. You can't say that she claimed like.
No, I'm not that.
No. She must be brought within OBCB.
OBCB.
In OBCB. Condition is that training came after the notification. Was permitted initially, but thereafter it was paused.
That's illness.
So you have kept having not as of the date of the or advertisement. What has what directed in the impute order?
Kindness.
What is directed?
To declare 1%, I tell you losses. Just judgment को था देखिए.
Please. 185 থেকে 85 আপনার paper okay.
All of your lordships kindly consider page 188, operative portion. Paragraph 8 of the judgment. In those circumstances that this court directs the Chief Secretary of the Government of West Bengal to ensure 1% reservation for the category of persons mentioned in NLSA supra above in all public employment in the state. 9. In the facts of the case and in exercise of extraordinary jurisdiction conferred on this under Article 226 of the Constitution of India, the court is inclined to direct the Secretary of the Board to arrange for interview and counseling of the petitioner as a special case. All of you are agreed by this. And recruit her as an assistant teacher in the primary school. Let a decision be taken by the Secretary Board immediately upon receipt of the copy. Well, this order I am assuming. I take your losses.
Lordship, this is order dated 14 June 2024.
24.
Page 185 of their paper.
And I tell you losses. 21st of June.
Lordship, they made one application for review after that. Lordship, regarding the inclusion of the facts that there were certain this is the
Subsequently, Lordship, they filed one application.
Is proper taking first memo of appeal. Well, clear mandate your lordships in the earlier order also.
Right?
It goes both orders. Now, আরেকটা হচ্ছে মানে judicially rectification আমাদের দিন ছিল না আপনি বলেছেন হ্যাঁ
হয়নি তারপরে দেখে তখন they have challenged both. Right.
But Judicial, so 14 months, 21 months. Yes, sir. The board is board is therefore directed to recommend appointment of the deputy. If that is the review application was taken out, this book. See that this two applications. Now, but this was not in the review. This was not in the review matter. This was in the petition. What the court held, whether is that this should be given effect with the reasons in 40. Five. There are 5 months. But the reason is already recorded in 14. Therefore, I have preferred that as modified on 21st. But I cannot, because if this is recorded in this fashion, then once one order merges, because the recordings are being merging here. Then or else if your lordship is saying that, then I will file another memo. But if your lordship kindly consider, because this last sentence is something which is in the nature of a merger of orders. As the court is really a merger of orders. Kindly, if your lordship, very technical point,
you can pay the court fees also both. I think. Double court fees. Supreme Court this is one of the order of the Honorable Supreme Court. Thereafter, other orders were also passed, but ultimately that's still pending for final hearing. These panels have been produced before the all data have been produced before the Supreme Court. There are other 2-3 orders, Your Lordship. Ultimately, Supreme Court directed take their interview in the meantime, subject to the SLP final hearing, and place it before the Honorable Court. That has been probably placed before the Honorable Supreme Court.
Pending.
Pending. That's pending. Right? On his instruction, I'm saying, my lord, he is a part. No, that's why. Well, I have to take from junior, my lord. No, no, he's a part of the process. He's a part of the process before this.
কারণ 20-22 সিলেকশন
Lordship, in the litigation, I am not the part of it. Lordship, that instruction I have. In the litigation, I am not part of it.
No, no, he's not a
I am
part
not
of the
part of
SLP. What I'm saying, Your Lordship, the panel that was prepared for the rest of the vacancies for those particular candidates, Kuri by session, those who have passed DLED, that have been placed before the Supreme. He's not neither a party to the before the High Court nor a party to the Supreme Court in the proceedings.
So whether my name is present in that panel, that I don't know.
And if Your Lordship kindly have a look at the
হ্যাঁ হ্যাঁ
Avik Lordship.
হ্যাঁ যেটা সুপ্রিম কোর্ট আমাকে বন্ধ করে পাঠিয়েছে
Sure.
হ্যাঁ
Well, I'm
জেনেছি
his name is there in that panel. Ultimately, if the Supreme Court says that we have to take them, then according to merits, they have been taken. They have to be taken. But Your Lordships kindly see the prayer. This is not the scope of the writ petition. I with all respect, learned single judge, travel beyond the scope. No, no, no. I tell Your Lordship because now today I am being taken into task by Your Lordships. I have not committed any. West Bengal Board of Primary Education. Ultimately, I have been directed, give appointment, give recommendations. I can't go beyond the rules. And I tell you, Lordship, this is probably, I'm not accusing someone. Well, he participated at OBC. Yes, I have. That's my independent appeal. I think,
12, item number
12.
এটা আমরা পেপার
And that's our paper book, my lord. State has not.
The Lordship, the first they said that not needed, but they have subject to correction.
And everything in this, our paper book.
Compiled all the documents.
All the documents are there.
Therefore, it's a paper book.
Everything is with you. এটাতে এরকম হতে পারে না।
না
Ratullah, নাম আছে ওখানে। ওইটা
যতজনের ইন্টারভিউ নেওয়া হচ্ছে সবার ডিটেলস বুঝতে
সেটারও পরে
দিয়ে দেওয়া হবে। দেখ যদি আমাকে জিজ্ঞেস করিস 2 পয়েন্ট অফ ল এদের কাউকে পাওয়া উচিত না কারণ ওরা তো জনেই আসে না ওদের তো সব ট্রেনিং কোয়ালিফিকেশনটা তো পরে
স্পিক সেন্স অফ
হবে যেটা আমি জিতেছি আমি তো ওইটাতে প্রাইভেট রেসপন্ডেন্ট বলছি বলে হচ্ছে যেটা চালু করে যাবে তাই জন্য এটা নোটরা সাইন করতে হবে আমি ইন্টারনাল দিদিকে And the other thing, if you losses kindly consider the judgment under appeal, the first judgment, if I take your lordships, page 186. Exactly. Well, kindly, I'm referring to that judgment. Well, recognition of a third gender in a particular way. If I paragraph 135.3, that's I'm trying. 135.3 of that judgment says we direct the center and the state governments to take steps to treat them as socially and educationally backward classes of citizens and extend all kinds of reservation in cases of admission in educational institution and for public appointments. Now the point remains here, Lordship, fact remains that is already in OBCB. Now, no, that's not a caste. I suppose I give an example. A Brahmin cannot come as OBC. Economic, socially and economically, both your losses judgment. Socially, they will not be considered as such. Socially, they will not be considered as backward. Brahmin. That's the judgment of the it's a very wide term. As I have read the judgment of the Supreme Court, Brahmins are not treated within the socially backward class.
Actually, even there are certain Brahmins who are.
That's economically, all Purut Mosai in the are economically backwards in Brahmin. That's
Ogrodani Brahmin.
But your losses, the judgment has not said only socially backward can be declared as OBC and executioner. That has not yet been permitted. That has not yet been permitted. And here your losses, one thing very important. Supreme Court says, well, that's have been done, Malad. We are sufferer. What can I do, Malad? I may suffers. And that's why I say all Purut Mosai suffers. And here your lordship says not even economically, socially and educationally backward classes. Supreme Court order. Your lordship can have a look at page 186. The judgment of Nalsa, your lordship says to take steps to treat them as socially and educationally backward classes. It doesn't refer to economically. That's your lordship, that's up to. I'm not right. Promogan, okay. I would like to.
But one very old matter of this bench, review is pending, Miller. If it, if your lordships may kindly fix a date, Miller. Miller, kindly Miller, pardon me, Miller, in saying this, but it has been mentioned at least 15 times. Please, please. Miller. এই দুটো আছে দুটো একই অ্যানালগাস দুটো অ্যানালগাস
আমি ফোন করি হ্যাঁ কিন্তু আমার তোমাকে আমি হ্যাঁ PM দুটো 2:30 মধ্যে একটা হচ্ছে আপনার
Yes. What is the report?
Yes, Miller. But may I hand up 82? May I hand up this report? But two things that I would like to, Milord, just Milord, request your lordship, Milord. Because of the paucity of time and Milord, because of the distance, Milord, I had to, Milord, get only scanned copies of the report because the person who has signed it could not, Milord, come down to Calcutta, number one. And number two is, Milord, the report is addressed to the state advocate, Milord, which is a crime. When I'm filing it before the bench, Milord, it shouldn't have been addressed to the state advocate. Kindly, Milord, pardons me, Milord, for that, Milord. But this is all because, Milord, of paucity of time, though. Copy them. Copy them.
আপনার হাতে
এটা তো আমার জজ সাহেবের গুলো কোথায় But the other thing is, Milord, with respect to my learned friend, the sincerity which he has shown yesterday in giving whatever was directed by the court. But I had to instruct my juniors to write through WhatsApp to him around 10 in the evening that I have not received it. The video had come to me at around 11:25 p.m. Number one.
Miscommunication.
This again shows your more sincerity. He may know many people by the name of Kishore Dotto, but he doesn't know that there is an advocate general by the name of Kishore Dotto. Therefore, it has gone to some other Kishore Dotto of Barakpur. This is the sincerity. And number two is the 10 names that he had disclosed before the court yesterday. That came to me at 8:25 a.m. At 8:25 a.m. Just a minute. Just a minute. Milord, he had rattled 10 names yesterday before the court.
5 names.
Whatever. Now, to give that name only with no additional information, I could have understood additional information was given. It comes to me at 8:25 a.m. today. I don't stare at my mobile phone. So I looked at it after coming to court today. On that note, I cannot assist the court. Insofar as the video is concerned, I have taken instruction, which is also part of the report. Now, this is the sincerity of a public interest litigant who comes before the court regularly.
Malad, I bow down because at the very first instance, when the matter was going on, I instantly sent it via WhatsApp. It named to some other person, namely Kishore Dotto. I was only made aware of it last night. It's my mistake on my part of the same name. Both are advocates.
And I had to write to them that it's 10 p.m. I have not received anything.
I got a call from Mr. Dotto's junior yesterday at night. Then only I realized it went to some other Kishore Dotto. So I just message করেছো বা call করেছো, whatever it may be. Now, my lord, if the sincerity and it's all about coming from the state, we all know what the sincerity of the police, because it's one of the cabinet ministers who expressed the inability of the police to function in the state.
So why there is a the objection or reservation on the call or a WhatsApp, whatever, or SMS? It's a brethren fraternity. It's a noble profession.
He has said he received, and he has said I called. Misunderstand.
No difficulty.
And my lord, with regard to the names that I had served later on, because there is no internet. Yes.
It is.
ঠিক আছে। আচ্ছা, এই যে ভিডিও ক্লিপিং এর ফাইলটা হচ্ছে ওটা দাও 876। এই ভাই এখানে ফোনে কথা বলছো কেন? হাইকোর্টটাকে একদম রাস্তায় নামিয়ে দিচ্ছ কেন? তোমার ইনস্টিটিউশন তো এটা, তোমার ইনস্টিটিউশন তো, কোর্টের সামনে তুমি ফোনে কথা বলে যাচ্ছ। আনফর্চুনেট। You people are so important that people can't wait for you. Get over a matter.
There are certain agencies.
Yes, yes. Go and respond to the call outside the court. Why inside the court? Heaven will not fall if it is taken up. Call is attended to after 10 minutes. এই প্রফেশনটা এখন তোমার আমার হাতে, এটা মনে রেখো। সিদ্ধার্থ রায়রা চলে গেছে, আচ্ছা ওইগুলো দাও। ইন্টারনেটে যে ব্লকিং গুলো হয়েছে সেটা দাও। হুম। বসো।
Yes.
My lord, a few more submissions, my lord, which, my lord, we could not, my lord, incorporate it in the report. Number one is, my lord, the video clippage that was, my lord, played before the court yesterday. But on that, my lord, a case has been registered.
No, that you have indicated in here.
Yes,
in
but
this
I have the
report,
FIR, my lord, if you,
could not identify that person.
yes, yes.
Why?
My lord, it has come only yesterday. My lord, give us some time, my lord, to, my lord, kindly have a look to, my lord, this FIR, my lord, I have brought for your lordship's consideration. Please have a look to the formal part of the FIR, the first page.
My lord, with the lordship's
My-
kind permission,
my
may I have a glance at the report?
We'll get it. Don't.
With serial number 3. No, এটা copy করছি। Rectifier টা দাও, সেটা হুম।
Yes.
But the other thing is, Millard, but kindly have a look to Millard these figures. Millard, these are Millard the social media circulations, Millard, that have been blocked. Kindly turn the page, Millard. Millard, on Facebook, Millard, there were 642 posts. Millard, we have blocked Millard 638, 4 are pending. In X handle, Millard, out of 230, 220 have been blocked, 10 pending. YouTube, Millard, 63, all blocked. And Instagram, 77, all blocked. Now, Millard, now kindly, Millard, take my learned friend's petition because yesterday it was just handed up over to me and Millard, we had to rush to court. Please have a look to Millard. The basis of my learned friend's petition, Mr. Kaustubh Bagchi's petition, kindly have a look. Millard, whatever is with the writ petition, whatever maybe is in evidentiary value, let us go by that.
Hey. অন্যটা বল।
Now, please take me to the first annexure, that is page 16, 16. Millard, this is Millard, one of Millard, some media reports by Seoshi Pal. Please take me to page number 17. At the top, Millard, above the photograph, a huge police contingent, including rapid action force, has been deployed at the affected neighborhoods. Well, kindly, Millard, then skip over the rest of the parts of that page 17. Now, please take page 18. Millard, fifth line from the top. The state's Director General of Police, so-and-so, said that a large number of Indian Police Service officers rushed to Beldanga on Saturday night. Local residents claim that at least 50 people from both communities suffered injuries and more than 30 houses were either ransacked or set on fire. The worst affected area, they said, is Beldanga Civic Ward number 10. The authorities deployed huge police contingent, including rapid action force, at the affected neighborhoods and shut down internet facilities across entire Murshidabad district until 8 a.m. on November 19. Where the rest, Millard, is the population part. Then, Millard, please take me to page number 20. Millard, there is a quoted paragraph, the second one. 4 Beldanga residents, including a woman, have been admitted in the hospital. A rapid action force personnel also suffered injury while trying to stop the back-to-back clashes. Then please take, my lord, page number 22. My lord, fourth line from the bottom, where my learned friend's anxiety. No fresh clash was reported till Sunday afternoon. This is his annexure. Next line, all police officers who earlier served in Beldanga zone has been brought back temporarily for their current location in view of the situation, an officer said. Then we have the next page, page number 23. Beldanga, the internet was shut down in Murshidabad and Jangipur police district, including the areas in Behrampur, such and such, and prohibitory orders were issued in some parts on Sunday, and tension between the two groups in Murshidabad led to clashes on so and so. 15 people were arrested for the violence. Police said that the situation is under control, and raids were on to nab other culprits. A large police contingent started patrolling the area. No fresh clashes were reported until Sunday night. After the tension ebbed, Kartikel Lorai, a century-old procession was observed peacefully at Beldanga. Then kindly, Milord, the rest, then Milord, the Bengali newspaper Anandabajar Online, please take, Milord, page number 26. Just above the photograph over there. But the last sentence over there, আপাতত পরিস্থিতি নিয়ন্ত্রণে রয়েছে বলে পুলিশের দাবি. Then, Milord, at the bottom of that page, the last 4 line, বেলডাঙ্গায় বিভিন্ন জায়গায় পুলিশ টহল দিচ্ছে, দুপক্ষকে সংযত থাকার বার্তা দেন জেলা পুলিশ সুপার। তিনি বলেন, স্থানীয় একটি বিষয়কে কেন্দ্র করে উত্তেজনা ছড়িয়ে পড়েছিল, আমরা দোষী ব্যক্তিদের চিহ্নিত করে উপযুক্ত শাস্তির ব্যবস্থা করেছি। সবাইকে অনুরোধ করব আইন শৃঙ্খলা পরিস্থিতি নিয়ন্ত্রণে রাখতে পুলিশকে সাহায্য করুন। উভয় পক্ষের কাছে আবেদন, আপনারা কেউ আইন নিজের হাতে তুলে নেবেন না। Then, Milord, my learned friends, email at page 28. Where in this backdrop, Milord, he makes a request to the Honorable Governor that there should be deployment of central forces. And then, Milord, at page 29, he's very aggrieved with this police post. Kindly, may I place this at page 29. Malicious efforts are being made from certain quarters to spread misinformation and rumors about last night's incident at Beldanga in Murshidabad, where clashes took place between two groups over some condemnable mischief. President and secretary of the committee where this incident took place have been arrested and taken in police custody. Prompt action has been taken by the police against vandalism and violence by arresting 17 persons. No casualty, repeat, no casualty has been reported anywhere in the district. 6 persons were injured and are under proper treatment. Condition of all injured is stable. Situation is under control. Sharp police vigil continues. Please do not heed unverified facts and figures being circulated on social media to disrupt disrupt peace. Sternest possible legal action will be taken against lawbreakers as also rumor mongers. Now, this police post, Milord, in my very respectful submission, was read out yesterday to demonstrate before the court that what the police is saying is absolutely wrong. Police is trying to paint a different picture. Now, that's why, Milord, I took the trouble to, Milord, take your lordship through the news media reports, irrespective of its evidentiary value, what they say and what the police has said, Milord, whether, Milord, there has been any disparity in that or not. In my very respectful submission, there is no disparity. Now, Milord, the other part that
there is one part.
Yes.
In your report, you have said many things. It appears that at one point of time, for the first time there was an disruption or eruption, the police personnel went and pacified the things and then tackled the situations. The police personnel are well aware of the reasons for such eruption of the I would say the violence or something. There is no other attempt on the part of the police personnel to remain there and keep a very strict vigil. As you go by your report, the second immediately is large number of people gathered and there was an attempt for a violence. Again, the police said, I went there and pacifies. Why not the police took very preventive steps immediately when for the first time it happens? How a large gatherings or the peoples can gather subsequently and then continued, because it was done in a phases as it appears from your report. It was not
Yes.
that at one go, it was on phases.
Yes.
And phases means there must be a gap of certain time. What was an attempt on the part of the police to combat this situation?
Milord, may I say this, Milord? The police had, Milord, taken action, Milord, as and when, Milord, the situation
becomes worse.
No, as and when, Milord, the situation arose, and thereafter,
That is what he says.
yes,
It becomes worse.
yes. No, it did.
When there was a commotion.
Yes, ma'am.
When some of the people
I
they
get your
came
lordships, yes.
and there was a clash.
Right.
The police said that I intervened. We went there and intervened immediately.
Right.
Thereafter, in the report says, then after certain, the gap of a time, another large number they came and then they started. My query to you is that when you saw that this is a very sensitive issue, then why not there should be a preventive measures taken by the police so that there is no further recurrence on this?
Milord, the police over here, Milord, had Milord rushed to the area. Yes.
This is what the report says.
Now, Milord, today, Milord, the condition is such, Milord, going by whatever, Milord, they have annexed to the petition, apart from what is being verbally said to the court, but at least, Milord, there is nothing on record to show that, Milord, the situation is out of control today. I very respectfully say the situation is within control. Number two, Milord, going by his annexures, Milord, there has been no fresh incidents. Number three, Milord, we have said, Milord, that the police contingent that has been rushed to that place, and Milord, that is over there. Senior police officials are there, Milord.
But they have given you certain names yesterday.
Not yesterday. Today, 8:25. 8:25 in the morning. I have it in my mobile phone.
Your report is that there was no information which was given to you. And the names which were given, I think, in course of the hearing that was given to you.
Yes, Milord, I couldn't follow, Milord. 10 names, Milord, is told to the court. But the court
any attempt on the part of the police administration to find out whether they are really the residents of that particular locality and whether they are still residing in their houses.
Milord, I'll have to take instruction on this, Milord, because I couldn't even, Milord, contact, Milord, the number one person over there to take, Milord, all instructions. But, Milord, there is an hint in my report.
I have seen that. That's why I'm putting a query to you.
Yes. But we have said that, Milord, as of now, Milord, there is no.
Yes. What I said yesterday in course of the hearing, 5 names were given.
I can file a short report on that also.
I understand 10 or 15. We are not going into the numbers. There were certain names which was given. Now, at least the genuine attempt must be shown by the police to identify whether they are the local resident
at all or not.
At all or not.
Right.
What are their houses, house number, whether they are still there in their homes. These things will come. Nothing.
But had my learned friend given it yesterday, I would have taken instruction. I've taken instruction on everything.
8:25 in the morning.
No, yesterday.
That's why I started by saying that these
names. 5 names. I read it in front of
no.
Any sheet or something you have given or what?
No, he has not.
I read it in court. The learned AG has said certain things with regard
to
those
if my learned friend is still pursuing his prayer for central forces deployment, but I have got some submissions to make. If he doesn't make this prayer, of course, but I'll not waste the time of the court.
Come with the instructions.
Because the situation.
What it appears from their petitions, the primary concern is the safety, security, and maintenance of peace.
Yes.
In the locality.
Right. But police has taken all steps, Milord.
And there should not be any discrimination to be perpetrated. There
Certainly not.
There should be an impartial way of tackling the issues. I think that is a paramount consideration for both.
Right. Well,
As a righteous person.
it's a welfare state, my lord, it is my responsibility. It goes without saying.
So this is what they apprehend, that there may not
Yes,
be.
now please consider, my lord, whether this apprehension is a justified apprehension or not. I am standing over here, sir, my apprehension is that the fan is going to fall.
No, my lord,
Whether it is justified or not.
the annex.
Based on whatever he has annexed, based on whatever is in circulation, and based on, my lord, whatever I have, my lord, submitted through my report, my lord, your lordships know, my lord, there has to be, my lord, my lord, দাঁড়াও না বাবা, এটা শেষ করে নি, আমি তারপরে একটা green light জ্বলবে। So, but based on whatever is before your lordships, my lord, I will very humbly submit, my lord, that situation is completely under control. Something has happened, no dispute on that. Police has taken steps. But we are very fortunate that there is no loss of life. There is some injury here and there, no doubt about that, but very few. And
Sure that proper medical assistance is
yes,
provided to all of them who have suffered injuries.
But it goes without saying, my lord, whatever, my lord, is required of the state will do that. My lord, if it doesn't require, my lord, the order of the court. But, my lord, I want to add one thing. But I have got, my lord, the posts of, since my learned friend, though a lawyer, belongs to a political party, my lord, the what should I say, high portfolio holders of the party that he comes from should also, my lord, stop circulating in the X handle and all that. But I've got a few with me. If your lordships want, my lord, I can place it before the court. Now that can also give rise to incitement. That should also, my learned friend should ensure that this doesn't happen. I have it with me. I don't want to name these persons.
Before going into all these things, whether that tantamounts to provocation or not, firstly, my lord, firstly, my annexures were relied upon with very selective things.
Yes.
What the state did, selective. They showed that everything is a very rosy picture, situation under control. Now, annexure at page number 24, it says over 30 houses and shops and houses were ransacked. The last line, the groups carrying weapons on the streets, locals alleged bombings. Several persons were injured and a number of people were missing. Now, the Bengali annexure that says, ঠিক কি নিয়ে সংঘর্ষের সূত্রপাত তা জানা যায়নি, তবে শনিবার বেলডাঙ্গায় যত্রতত্র গন্ডগোল শুরু হয়, ভাঙচুর চালানো হয় এবং দোকান এবং বাড়ি ঘরে অগ্নিসংযোগের ঘটানো হয়। বেশ কিছু জায়গায় ধারালো অস্ত্র হাতে দাপাদাপি করতে দেখা যায় বেশ কিছু ব্যক্তিকে। এলাকাবাসীর অভিযোগ মুহুর্মুহু বোমাবাজি হয়েছে, তাতে বেশ কয়েকজন আহত হয়েছে। পাশাপাশি রাত থেকে বেশ কয়েকজনের খোঁজ পাওয়া যাচ্ছে না। These are also parts of annexures. Now what the state has done, my learned advocate general is very much pleased towards the police administration, but one of the cabinet ministers of the state has showed their inability, that the police is unable to function in this state. I can bring it on record by filing a way of a supplementary affidavit. There are statements of a cabinet minister of the state saying that police is unable. They are not at all able to tackle the situation. So these are all, my lord, facts. My lord, what we are saying, my lord, police is not been able to tackle the situation. Large number of people they are missing. The reason why I could place it today in the morning, because I am not being able to contact them.
But let these come by way of pleadings. Let these come by way of pleadings, not by, my lord, oratory submissions.
Not oratory, unless
let it come. Then, my lord, may I place his pleadings? My lord, we cannot fight litigations like this. This is not a political forum. That one-sided
the situation now.
Situation, persons from the Hindu communities are not being able to reside in the area. They are
I strongly, my lord, I dispute this.
There was an order yesterday which was passed.
Yes.
That
the email, the difficulty with the email is, since internet is suspended, how can they contact?
No.
Then how is he making these submissions?
For this WhatsApp message, I got this names via WhatsApp message. A person had to come all the way down to Krishnanagar to send that message. Even the areas of Tehotto and all those areas also, internet and all are suspended. The entire area of Beldanga, Tehotto and all those areas. Person had to come to Krishnanagar to send that message. So I could send it today in the morning.
না ওটা না, এই লাস্টে যেটা এলো সুকান্ত মজুমদারদের অমিত মালব্য সুকান্ত
And my lord, it was in the district of Murshidabad. Had they taken
Sir, litigation file for secular result.
কি পাওয়া যাচ্ছে এই জায়গায় থাকে কবে আজকে না লিস্টে আটকে থাকবে
my lord, one thing, what had fallen from the state that there has been statements from various leaders from the opposition dispensation. Now, my lord, we all know police at certain times have to take preventive steps. It was on one occasion, few months back, one of the members of Legislative Assembly from the ruling dispensation in the district of Murshidabad, he had commented that আমরা 70 ওরা 30 কেটে গঙ্গার জলে ভাগীরথীর জলে ভাসিয়ে দেব. This sort of statements, does it not tantamount to provocation? It is the district of Murshidabad and it is surrounding areas
But
of
I
Delhi,
cannot
wherein this
respond
sort
to
of
this.
persons.
I cannot respond to this. I can name 10 persons of his political party also, including film actors. He should not, my lord, make it a
But
political
the only
forum.
thing is that to instill confidence in the minds of the public at large. It's what I am saying before your lordship, persons of the Hindu communities in that area are not being able to reside because that the area demography is the majority belongs to the Muslim community and Hindus are the minorities of that area, and they're not being able to reside in their respective.
My lord, I dispute, my lord. I have taken instructions.
There was already a direction that to ensure their safety and security, it is a duty of the police to see that they live in their houses. So
Now with the suspension of internet, no news as per the
what would be according to you? You are also in doubt that what is the prevalent situation there?
But what I humbly beseech your lordship is there is a BSF camp nearby.
Now, some the peace is restored or the situation is under control, but there has been a divergent.
My lord, what I say is, what is the harm?
But he is not a person of that locality,
আমি একটা কথা বলি,
or not of that district. Why is he saying all these things, but who doesn't reside over there?
And we are সে মামা বাড়ি পিসে মশাইয়ের বাড়ি ওগুলো বলে লাভ নেই. What
are all politically motivated petitions?
This stray comments.
Of course.
What I'm saying.
I stand by what I'm saying. It's not a stray comment.
What I'm saying is, state says that they want peace. We say we want peace. Now, to instill confidence in the minds of the public at large, it's evident that in presence of police, clashes occurred. Even after they took control of the situation, clashes occurred.
No. No.
It's there in the report.
No.
From your lordship.
You state from your petition.
Well, it was that reacted.
What I humbly beseech your lordship is, my lord, state wants peace, we also want peace. My lord, there is a nearby BSF camp. If there is a deployment
The
of
state
certain,
is competent to restore
what
peace if
is
at all.
difficulty that what I am beseeching your lordship, we all are in a situation, we are all in dark with regard to the situation. I am getting calls from various persons with very low network. Certain the calls are getting dropped and all situation is as such. Now, my lord, if there is a deployment of central armed police forces, what objections the state has?
No reaction to it. Suppose if the independent persons, if they go and assess the situation and submit the report, then what is your?
Yes, absolutely, my lord. Absolutely, as it falls from your lordship, I have no objection. If independent persons over whom the state of West Bengal has no control.
Lordship, I have a separate prayer in regard to that. Let me kindly submit.
We can have a consensus to that effect, my lord. Persons from the center as well as from the state, let a team be constituted and a report be placed.
Why?
Lordship, there is
The
a
central
separate
doesn't
prayer.
have anything to do with
Please,
the law and
in
order.
regard to this, Lordship, actually, Lordship, this is a question of sovereignty of the state, Lordship. This is a question of sovereignty of the state. Whether the light system owner where from the issue actually had been cropped up on that day of Kartik Larai, he had been at all identified or arrested. Whether the state can show that the person who provoked a particular community to invite.
And four people in respect of each of those cases have been arrested.
Yes.
Let them come with an affidavit.
They have
Demonstrate.
said that so each peoples are there.
Yes.
They have also registered a case super on the basis of that audio clip.
Yes,
And,
Lordship.
they are saying that we are attempting or finding out that who is this
Situation
person.
is in control.
Yes.
And therefore, definitely, if the identity is,
Okay.
I think the person is identified, then something will be taken.
Yes.
Now we are concerned more with the, as Mr. Bakshi says, with the restoration of a peace.
Yes, Lord.
Or a harmony amongst the inhabitants of the local.
Absolutely, Lordship.
A maintenance of the peace, law and order and everything.
Everything under control.
Now they say that it is under control. You say, I mean, Mr. Bakshi says that we don't know, we are in dark, but we are receiving some
Lordship, internet connection has also been suspended.
some phones from a distant place. This talks about that many people are still not been able, and the situation is not.
Yes, Lordship, because internet have not been restored. Yes.
What we say. Internet something, the real picture has to come.
Yes.
Definitely, the state has an obligation to restore.
Yes. Yes, Lordship.
Definitely, a person being a citizen of the country has also
Yes.
and constitutional obligations to come before the court.
Yes.
For the fundamental rights to be protected of the people.
Yes,
in the
Lordship.
public interest. So that is what we were thinking that what to do. Because the report is also, they say, because of the scanty or a lack of time, we could not.
Yes.
But whatever we have done. So we have to, because we cannot sit idle, nor we think that the matter should be settled.
Yes.
Definitely, something is to be done. Then what would be the proper way of doing it? That is what we have to find out.
Yes, Lord.
It's a public interest litigation, is not an adversarial litigation.
Yes.
Absolutely, Lordship. Yes.
Milord,
It's an adversarial. What best for the citizen of the country we can do?
Yes.
That is what we have to consider.
That should be come with
Yes,
an
Lord.
affidavit.
Milord, may I
That should come with an affidavit. Submission from the bar.
My intention is different, not to keep peace on that.
No, actually, I on the of the Sudan definitely because when you clear particular
Yes, yes, there. There.
yes, and it's
Well, I this proposition. I'll make my submission. Yeah. Right. Please hear me.
All these were on submission. They come with an affidavit. So give me-
But he cannot.
Infrastructure কি করে করবে?
No, writing it. There is no law. How can the union government act without a law? I'm sorry. Yes, Millard, I'll demonstrate, Millard, on legal issue. Millard, my learned friends will kindly, Millard, tell the court under which provision of law he is making this submission.
আরেকটা কথা এটা বলে দাও যে all these are on submission. There is no affidavit.
No affidavit, nothing of the sort.
Come with an affidavit, we shall deal with it.
on the earlier occasion on this matter extensively arguing and also delivered a judgment.
I have that with me.
That is delivered on the interpretation of the service schedule. This one, the independent power of the government of India to deploy paramilitary forces in a disturbed area, not subject to what is in list 2. That is the law. And list 2 also says, 21, this is subject to the list 1. Therefore, my lord, directly deploy that. And as on that, this instruction we have got, the investment of the armed forces in West Bengal.
West Bengal armed forces.
আছে BSF আছে
Is required in it.
Towards the bottom, my lords will find summary of the company required investment. All
অনেকেই আছে আছে অফিসার আছে
Sir, may I explain what of summary of Well, how can we make an independent assessment without
Yes.
representation?
Yes, they have no right.
That representation
Sure.
ought to have been brought to the notice of the Home Ministry for having an independent assessment. Secondly, the intelligence branch, the SIB of West Bengal, they cannot give any report to your lordship. It's a confidential report. They send it to the Home Ministry. That you have not got instruction. The matter was taken up just with notice. Copy of the petition was given to us and handed over to me yesterday in court. Then my lord won. My lord won. Get the instruction finally.
অনেকেই আছে
Prior to your lordship's passing of any order or
Millard, may I
anything.
Millard,
only
may I
one
make
thing.
some submissions made on what? Acha, Yes, yes.
Mr. Dotto was relying upon page number 29. Now, what I was pointing yesterday, I'm just repeating once again, my lord, there is a self-contradictory stand on the part of the police. What they've emphasized is no casualty, repeat, no casualty has been reported anywhere in the district. Now, again,
My
they say
learned
6
friend
person
possibly
injured.
doesn't know the meaning of
Yes,
casualty.
yes, yes.
Whatever is there,
Yes.
the report has come. The report indicates there has been a not casualty. Casualty and injury are two different concepts.
Yes.
So according to you also, there was no casualty as such, but the several persons were injured. Casualty connotes that somebody has been murdered or
There have been instances as such.
have you got the
Yes, 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 yes.
got the body or something of that kind. Disclose.
ওই হবে এমনি লোক মরবে রোগে মরবে বলবে এতে মরেছে
Large number of people who have been injured, that is also admitted by them. There's no difficulty. But casualty, I believe, neither you have said nor anywhere.
But we cannot bring it on record because everything is.
Bring it on record. He cannot make submissions from the bar.
Cannot.
How am I to respond? Yeah.
Yes, you know, these.
A PIL seeker will not make any research.
To that, if they say there was no casualty, and then it appears there was a casualty, it's a serious issue.
Yes.
Scenario will be
It
changed.
will not spare. Will not spare.
My lord, what had fallen from your lordship, my lord, if a team is being formed, my lord, with that of the state and that
So
comprising.
he cannot make that submission.
My lord.
Under which law is he making this submission?
And from
But he has never, with respect, but I do not point fingers at the my fraternity.
Yes, said that what has fallen.
But after all, Milord, he is an advocate. He should come and point out some law.
Come with an affidavit.
Some law which permits.
He cannot say. Who cannot dictate the court?
Your report appears to be a bit scanty. You say that certain information has been received by you in the morning. Now you have received the information. We wanted I think, the detailed report in this regard. We also wanted him to bring certain facts which now is by way of affidavit before us. And we also wanted the center to give his assessment to the situations and then submit what information they have. Let us see. We are making this.
But on that note, kindly permit me to make some submission. So far as the central party is concerned, Milord, kindly hear me. Please hear me on this, Milord. First is, Milord, your lordships know, Milord, that the central does not have the power under the constitution to frame any law.
Talking about that, I just wanted the assessment of a situation. To be given.
No, but how was the central government here? Why not the USA government made party over here?
He cannot appear.
Why? This is not with respect. Yeah.
Structure will
Yeah.
Yes, I'm saying the word. Simply BJP people has come, that's the reason federal structure will go.
Yes, and central government will be made unnecessarily party.
Court can ask.
Yes.
How much have you chief minister, brother? Central Kadipur ask.
It's not an adversarial litigation. It's not an adversarial.
Kindly see, Milord, your lordship should comment on this also.
Yes.
Making unnecessarily, Milord, the central government and the central agencies parties and moving the court and looking at the central agencies advocate and Milord, the court's attention is invited that please ask the central government to file a report. Milord, this is a practice, Milord, which should be given up. Kindly look into the cost title of the writ petition. Please have a look to it. What has these people got to do over here?
Call for the yes. Survey copy, then come. His own.
But up to 5, all right. Yes, in every matter this is going on. Kindly take judicial notice of this. This has to stop. There's a public interest litigants, Milord, cannot take the court for a ride. Milord, I have made these submissions over and over again. That it is not that politicians cannot file litigations, but you should prevent the politicians from filing litigations to have a political mileage. Milord, a person of Calcutta A lady of Howrah has tears in their eyes for Murshidabad. There is no advocate in Murshidabad practicing in this court.
Whether that is impermissible.
Of course, it is a point to be noted. And what research has he done? Yes, when I make submission, I will support it. Now kindly see the cost item.
He was concerned. Mr. Banerjee. Yes, my lord. Sorry. When your advocate general is making a. I'm sorry, my lord, but lordship kindly, kindly don't expect it. I expect it, but I'm. It is also not expected. Then why not know? The ex-honorable Chief Justice has cautioned him for his submission. And I'm sorry, my lord, I'm sorry. I am sorry. I'm sorry with your lordship because advocate general is here, but he has compelled me. The lordship knows. The honorable Chief Justice is then cautioned him in court. Cautioned him in court. Sorry.
But I'm sorry, my lord.
Tell me, my lord, I will go out of the court. That is but I will not tolerate. I will not tolerate your attitude. But that is not the way. When your senior is there, he's talking. He's so gentle, my lord, he can't. And we are tackling, we are shutting them. We are sorry, my lord, I'm sorry. I'm sorry with your lordship, but not to you. We are just trying to find out the solutions. We are trying to find out the way. It's not adversarial litigations. This is not expected. I'm not expecting, but I'm sorry to your lordship. I'm sorry. But kindly caution him. This is not. We have already prevented him. If he was, then we say no. When he's making submissions, you can't. Have we not prevented him? That is an instance, my lord, your lordship. That's not. He was talking about how to tackle a matter we know. The bench controls. Yes, well, I'm taking leave from your lordship, my lord. Yes, he will please.
I'm sorry, my lord.
This is not expected. Well, I'm coming. I'm taking leave, my lord. Lordship, kindly grant me leave. Come across in my career.
My lord, I apologize. My lord, I apologize.
I'm tendering apology. I'm taking leave for 5 minutes. 5 minutes. You are making your submission. The court is listening to it.
Right.
You have a right to make your submissions to a suggestion. Here, the court gives. Here, Lord Advocate General. I'm coming. I'm taking leave.
But I'm sorry, my lord. Kindly look into the, my lord, cost item.
We have seen those.
Yes. No, kindly see. Respondent number 6 is.
They have made the directors as respondent.
No, but there has to be a reason for that. Yes. How are they necessary and proper parties?
General, one thing is that so far as the expunction of their names, deleting them, striking out their names from the past record is one aspect of them. Now,
the important aspect is, my lord,
the public interest litigation. Let us see, because concern is, as I said, again repeat, the concern is the purpose of the locality must be put in a very safe and congenial.
People of the locality has not come. People of the nearby districts have not come.
The concept of PIL originated for that reason, that the people who could not come.
Because the concept of PIL also says that unscrupulous busybodies should also not be entertained. Meddlesome interlopers, busybodies, they should not be entertained.
Coinage of the good word.
Yes.
But has to be.
My lords have been coins.
It has to be understood in a subjective manner.
Yes.
Anyhow, we were just trying to find out the way.
Yes. My lord, yes, I quite appreciate. But my lord, not at the instance of the central government.
Yeah, we wanted him to disclose by way of an affidavit something more.
And let him disclose. Let him disclose. Yes.
But we wanted to have the assessment of a situation.
Yes.
You have projected, we are saying, there is some kind of a, I would say, the dissent in them. They are not fully agreeing that what you said is absolutely correct.
But he cannot disagree. Because there is always a presumption of validity of, my lord, Judicial and Administrative Act.
Let us have the situation or the correct scenario from all ends.
But I am giving the correct situation, my lord. My lord, kindly permit me to make these submissions, my lord. But kindly permit me to make. I'm sorry, my lord, I am detaining the court. I'm sorry, I am detaining the court. My lord, there is a prayer that something must be done by the central agencies. The question is whether this kind of a prayer can be made by any citizen of the state. Well, my respectful submission would be, Milord, this cannot be. Milord, this has been, Milord, considered by the parliament, where the parliament, Milord, brought in, Milord, an amendment to the constitution. Then that amendment has been deleted from the constitution. Now, Milord, kindly see, Milord, this judgment, Milord, quotes, Milord, section 257A. That's why, Milord, I'm showing this, because now that 257A is not there. Copy though. Joseph.
এটা আপনি আপনার অনলাইন
আরে আমার কাছে আছে, জজ সাহেবকে দাও।
এটা আপনার না, এটা যাচ্ছে
জজ সাহেবের দাও।
Yes.
No, please consider, Milord, whether this kind of submissions can at all be made. Well, kindly take, Milord, for the purpose of, Milord, what was 257A, please have a look to, Milord, these paragraphs, because this now the books do not have, Milord, 257A quoted. That's why. But here, Milord, as your lordships are aware, Milord, two legislations were under consideration. One central legislation, the other is the state legislation. Now, please have a look to paragraph 17. 17. But these kinds of prayers cannot at all be made.
Brother judge.
আরে এতক্ষণে একটা কপি করা যায় না, মামলাটাই তো চলছে 1 ঘন্টা ধরে।
We are sharing it.
No, give me a moment, sir. Give me a moment, sir. 982109. 982109.
We can share it. You can refer it. Prior to the Constitution.
Prior to the Constitution, 42nd Amendment, the relevant entries were as follows. List 1, Union list. Entry 2, Naval, Military and Air Forces, any other armed forces of the Union. Then list 2, entry 1 was public order, but not including and using naval, military or air force or any other armed forces of the Union in aid of the civil power. Then, Milord, the change takes place in the Constitution. By the 42nd Amendment, entry 2A was inserted in the Union list. This entry reads as follows: deployment of any armed force of the Union or any other force subject to control of the Union or any contingent or unit thereof in any state in aid of the civil power. This phrase is very, very important. Civil powers, jurisdiction, privileges and liabilities of the members of such forces while on such deployment. Then entry 1 of the state list was amended to read as public order but not including the use of any naval, military or air force or any other armed force of the Union or any other force subject to the control of Union or of any contingent or unit thereof, again in aid of the civil power. Now kindly see what amendment under 257A was brought. By the said amendment, Article 257 was also inserted, which was in the following terms: assistance to states by deployment of armed forces or other forces of the Union. The government of India may deploy any armed force of the Union or any other force subject to the control of Union for dealing with any grave situation of law and order in any state. Any armed force or other force of any contingent or unit thereof deployed under Clause 1 in any state shall act in accordance with such directions as the government of India may issue, and shall not, save as otherwise provided in such directions, be subject to the superintendence and control of the state government or any officer or authority subordinate to the state government. Parliament may by law specify the powers, functions, privileges and liabilities of the members of any force or any contingent or unit thereof deployed under Clause A during the period of such deployment. Milord, Parliament thought it fit that the Union government should be empowered to deploy forces in case of need in state. 257A was brought because there was, before the 42nd Amendment, there was no power to the central government to deploy central forces in state. Therefore, my lord, by the 42nd Amendment, 257A was brought in. Kindly see the next paragraph. 257A article was deleted by the constitutional 44th Amendment. Therefore, 257A is not there today. Please consider how can my learned friend, the learned ASG, say that if the court directs the union government or the Ministry of Home Affairs will consider and take a decision. No, I'm not finished. I'm not finished.
The bottom line of this, what we gather is,
yes,
though Article 257A was deleted, but
2A is there.
It was retained.
Yes, now 2A was retained. What is the effect of that? Now, please take, my lord, paragraph 24. My lord, on 2A, my lord, paragraph 35 is there. I'll come to that, but please take paragraph 24. Or 21, my lord, kindly, please have a look to my lord, paragraph 21, the question framed by the Honorable Supreme Court. But 21, please go to my lord, page 130. I don't need to read the entire paragraph. Please come to page 230, just Placitum A. What is therefore required to be examined is whether the subject matter of the Central Act falls in any of the entries of the State Act, because there are two statutes which were being considered over here. The submission of the learned counsel for the petitioners and the intervener is that the Central Act is a law with respect to public order and falls under entry 1 of state list. So this is the question which the Supreme Court has posed for itself and is considering. Now please take me paragraph, I skip over the submissions. Please take paragraph 24. A perusal of entry 1 of the state list would show that while power to legislate in order to maintain public order has been assigned to the state legislature, the field encompassing the use of armed forces in aid of the civil power has been carved out from the said entry, and the legislative power in respect of that field has been expressly excluded. This means that the state legislature does not have any legislative power with respect to use of armed force of the union in aid of the civil power for the purpose of maintaining public order in the state, and the competence to make law in that regard vests exclusively in the parliament. Prior to the 42nd Amendment to the Constitution, such power would be inferred from entry 2 of the Union list related to naval, military and air forces and any other armed forces of the Union, as well as Article 248 read with entry 97 of the Union list. After the 42nd Amendment, the legislative power of the Parliament in respect of deployment of armed forces of the Union or any other force subject to the control of the Union or any contingent or unit in any state in aid of civil powers flows from entry 2A of the Union list. The expression, where this sentence is very important. The expression in aid of civil power in entry 1 of the state list and entry 2A of the Union list implies that I paraphrase it as 1, deployment of armed forces of the Union shall be for the purposes of enabling the civil power of the state to deal with the situation affecting the maintenance of public order, which has necessitated the deployment of the armed forces in the state. The word aid postulates the continued existence of the authority to be aided. This would mean that even after deployment of the armed forces, the civil power will continue to function. The power to make a law providing for deployment of the armed forces of the Union in aid of the civil power in the state does not comprehend the power to enact a law which would enable the armed forces of the Union to supplant, to act as a substitute for the civil power of the state. Now, I'm pausing here for a moment, my lord. Today, my lord, if central forces are brought, that you work with the state government, please consider, will it not amount to supplanting or substituting? Either it will be supplanting or substituting. Now, that is the prayer. Now, let us go further, my lord. We are, however, unable to agree with the submission of the learned counsel for the petitioners that during the course of such deployment, the supervision and control over the use of the armed forces has to be with the civil authorities of the state concerned, or that the state concerned will have the exclusive powers to determine the purpose the time period and the areas within which the armed forces should be requested to act in aid of the civil power. In our opinion, what is contemplated under 2A of the Union list and entry 1 of the state list is that in the event that deployment of the armed forces of the Union in aid of the civil power in a state, the forces shall operate in the state concerned in cooperation with the civil administration so that the situation which has necessitated the deployment of the armed forces is effectively dealt with and normalcy is restored. Now Milord, kindly take paragraph number 25. Please come to Milord Placita D. With just one line after Placita D, maintenance of public order involves cognizance of offences. Such seizure and arrest followed by registration of reports of offences, FIRs, investigation, prosecution, trial, and in the event of conviction, execution of the sentences. Then with the last 5 lines of that paragraph, Section 4 of the Central Act do not enable the armed forces of the Union to supplant or act as a substitute for civil power of the state, and the Central Act only enables the armed forces to assist the civil power of the state in dealing with the disturbed conditions affecting maintenance of public order in the disturbed area. This is in the backdrop of a central legislation. Then the Supreme Court was considering what is disturbed area. Before that, kindly take paragraph 35 at page 138. I will not read these paragraphs as a whole. But the second line, at page 138, Parliament was competent to no, may I read it in its entirety? Please take paragraph 35 from page 137. As regards the competence of the Parliament to enact the Central Act, we have already found that keeping in view entry 1 of the state list and Article 248 read with entry 97 and entries 2 and 2A of the Union list, Parliament was competent to enact the Central Act in 1958 in exercise of its legislative power under entry 2 of Union list and in Article 48 read with entry 97 of the Union list, and after the 42nd Amendment to the Constitution, the legislative power to enact the legislation is expressly conferred under 2A of list Union list, and it cannot be regarded as a law falling under entry 1 of list 1. Therefore, 257A Yes. Now kindly take me lot 36. Where on the drop of a hat, made with respect, kindly do not mind my language. People come and say that deploy forces, deploy forces. When is the situation? Kindly take me paragraph 36. Please take me at Placita E onwards. In my very respectful submission, before reading the paragraph, one individual or a bunch of individual cannot come and say that this area is disturbed, this area needs deployment. Kindly see my paragraph 36, Placita E. Since the use of armed forces of the Union in aid of the civil power in a state would be in discharge of the obligation imposed on the Union under Article 355 to protect the state against internal disturbance, the disturbance in the area to be declared as a disturbed area has to be of such a nature that the Union would be obliged to protect the state against such disturbance. In this context, reference may also be made to Article 257A, which was inserted in the 42nd Amendment with entry 2A of the Union list. Although 257A has been deleted by the 44th Amendment, it can be looked into since it gives an indication regarding the disturbance which would be required for the deployment of armed forces of the Union for use of the civil power. The said article provided that the Government of India may deploy any armed forces of the Union for dealing with any grave situation of law and order in any state. It can therefore be said, this part, this is the satisfaction part. For an area to be declared as a disturbed area, there must exist a grave situation of law and order on the basis of which the governor, administrator of the state, union territory, or the central government can form an opinion that the area is in such a disturbed or dangerous condition that the use of armed forces in aid of the civil power is necessary. It cannot therefore be said that an arbitrary and unguided power has been conferred in the matter of declaring an area as disturbed area under sections 2B read with section 3 of the Central Act. Therefore, this is the mechanism. Somebody coming and saying, my lord, disturbed area, writ petition, nobody can approach the court, internet suspended, it does not become a disturbed area. But this is, my lord, how, my lord, this satisfaction has to be reached. Because after all, my lord, in the federal structure, my lord, law and order is a state subject. To override that, my lord, there has to be a situation which is beyond control, number one. Number two, in aid of civil power. Therefore, the power remains always with me. But have the state come before the court, or has the state gone before the union government saying that I need your assistance? No. Now, please consider, my lord, this federal structure, my lord, cannot be, my lord, substituted. But at the instance of, my lord, some person, my lord, as the litigation progresses, my lord, I point out more fingers at the petitioners because they are persons who are not of the locality. One of them is known to be a political personality. These petitions have not come from the nearby areas. I can understand everything is blocked in the Beldanga and Murshidabad, what they are saying. Let us assume it for argument's sake. The local people have not come. We have said that there has been no complaint. We'll take instructions on whatever names have been given.
Let us see, we will take care of this.
Yes.
as well.
Yes.
And let us interpret what the Constitution bench of the Supreme Court really wanted to say on this. So let us.
Yes, let him come by way of an affidavit, bring it on record, we'll deal with it.
You also file a further report.
Yes, yes.
Let us think whether we can ask the center to give its independent assessment of the situation or not. We will consider, because you have argued.
Yes, yes, definitely.
The juxtaposition with this judgment.
Yes, yes.
Of the Supreme Court. But I have got a submission. What more submissions? Submission I have not done anything. Sir, we wanted that. What is your independent opinion on that? You could not say that you have gone there and to make an assessment. So that is one submission from central government has nothing to do with it. Why central government has made a partner? Not there. Not read. Residuary power under Article 256 and 257. Then comes the question of A and amendment.
So the law,
The residuary power.
I'll be out of court.
Control over objects on law. Let him. Kindly allow me to press it. This such an allegation has been made by central government.
No allegation, it's a interpretation of the
application. No, kindly appreciate what is struck down the Constitution. Not an application. Mr. Interpretation of the judgment of a Supreme Court Constitution bench, and he wanted to interpret in his own way. You have a right to interpret in your own way. Yes. Yes. Kindly come to para 74. Yes. In the light of the above discussion, we arrive at the following conclusion. Yes. Parliament was competent to enact central exercise of the legislative power conferred. No difficulty. No difficulty. This one, all that. Yes. This is the power on the basis of which PSF Act, CISF Act, and the CRPF Act, all these acts were enacted. Number kindly come to para 2. The expression. The expression in aid of the civil power in capital A of list and entry 1 of list 2 implies the deployment of the armed forces of the Union shall be for the purpose of enabling the civil power in the state to deal with the situation affecting maintenance of public order, which has necessitated the deployment of the armed forces in the state. Now comes the good question. That is to be that has been already advanced for your lordship. If these internet facilities are all suspended, the presumption is that this is an disturbed area. Number 1. Number 3. Para 3. Of this para 74. You are aid postulates the existence of the authority to be aided. This would mean that even after deployment of the armed forces of the civil power will continue to function. Now, lordship will finally come to list 2 of the Constitution of the 7th century. List 2. I'm ready.
পুরোটা পড়ে নাও না, পুরো 74টা পড়ো, তারপরে তুমি
Of the 7th century, public order, entry 1, entry 1. Yes. Public order, but not including use of any naval, military, or air force, or where? This 2. 7th schedule, entry 1. Public order. Public order, but not including use of any naval, military, or air force, or any other armed forces of the Union, or any other forces subject to the control of the Union, or of any contingent or airport, or in aid of the civil power. Therefore, the power inherent in the unitary constitution is with the central government. And and secondly, Lord, if it happens.
Legislation has to on the acts.
And the constitution has categorically summarized in para 74 the aid of civil power. Not absorbing and taking out the civil power of the state. Therefore, the entire para 74 has to be read for interpretation of this question. And kindly, my lord, I am again, my lord, submitting and beseeching your lordship to go into Article 256 and 257 independently. The residuary power under the Constitution, unitary structure of the Constitution, not federal. To power of the central government to control over the state.
But I was only making the submission. Where is the legislation? He has not pointed out to those legislations. And the legislations are all purpose specific. BSF has its own jurisdiction. CRPF has its own jurisdiction.
We are not entering into that. We are simply going by the judgment and the observations of this constitutional decision. Our judgment is also there.
Yes.
On that. Para 4, your losses have been categorically pleased to hold following the Naga case. I am reading just only one
over and over.
Para 4.
কখন হবে
Page 4.
সিচুয়েশন
Last
কন্ট্রোল থাকে
one
তখন
paragraph.
এটা বলে দাও লাস্ট
In furtherance with the same, the apex court also considered that the deployment of the armed forces is in effect in aid of maintenance of the public order in an area
Identified.
and it is within the domain of the central government to take a decision in this regard, and the deployment of the armed forces and other forces in the state is inevitable.
সেখানে হয় সিচুয়েশন
Then after the Naga's case, summary conclusion in Para
বলে দাও যে সিচুয়েশন কন্ট্রোল থাকে তারপরে হবে কি
But my argument is that
we
it has to be declared as a disturbed area and the modus is under paragraph 34 of Naga.
and এখন কন্ট্রোল
No legislation is there. Power is there. Let him exercise that power.
নেসেসিটি অর নট সেটা জজ সাহেব দেখুন
file your report, which you have said, by Friday. And you also file your supplementary affidavit.
Yes.
The affidavit disclosing the further facts by Friday.
Yes.
We have also directed you to file your reports disclosing your overall.
Lordship, the police report, we haven't even,
Friday. And the matter would appear on Monday.
Before this bench.
Has to be.
Lordship, the police report, actually, we have not got any chance to see at least, the police report, actually.
This was in the form of a letter, which we have
Okay.
indicated.
Okay,
It is
Lordship.
not really a report,
Okay, Lordship.
to which London AG has very categorically said that this is not.
Okay.
So we have said report in the form of an affidavit to be filed, so that
Yes.
you will get a copy of the.
Yes, Lordship. Absolutely, Lordship. Deeply obliged, Lordship.
Would be at 2 p.m. Milord?
Yes, obviously. If you want a morning, we can sit on in the morning.
The 2 benches have to wait.
Yes.
Well, item number
2 p.m.
item number 3. Yes.
Deeply.
Thank you.
But item number 3, I am for the appellant led by Mr. Jetmala Nimilad.
Lord, I am appearing for the respondent in this matter.
But there are two.
Lord, I am taking a point of maintainability
But there are two
as
ladies.
regards appeal.
But there,
Appeal maintainability, my lord, I am taking the points of maintainability of the appeal.
but there are two ladies before your lordship. There are two lady. Lord,
Where is the impugned order?
Lord, impugned order we have. Lord, it is with your lordship's brief memo. Stitch with memo.
11th November.
Yes.
Just give us 30 seconds time.
Yes, my lord. Copy that.
আমাদের কপিটা দিয়ে ওই অর্ডারের কপিটা অর্ডারের কপিটা আপিল হয়েছে ইমেল কপি সব কমপ্লিট।
What has happened?
My lord, although my lord, we have challenged the investigational malafide in.
My lord, I have a point, please. My lord,
18th November, where? 15th December.
no, that is orally.
Orally, it was
It was a notice, when the date was fixed on 18/11.
1811.
What
Then,
has happened on-
then, my lord, we moved this applicable the appeal. My lord, verbally, Malayasi Chief Justice sitting with Malayasi Bhattacharya, my lord, they have passed a verbal direction that till 20th no action will be taken. It was a verbal direction. Now, my lord,
not the no action, now you will not be,
will not be, my lord, no coercive action will be taken.
not the
Now-
verbal direction, my lord. It's a, no. It's a desire of the court and I agreed to that.
Whatever my senior
No,
friend
that's
says,
right.
my lord,
But
I
my lord,
was
I have
not
a
there.
point of maintainability of the appeal itself.
Lord, I shall
Would your
satisfy.
lordships, my lord, hear the point of maintainability first or hear the merit?
Point of
My lord, this is latest patent appeal is not maintainable.
Why?
Against, my lord, the order, when an order has been passed by the writ court, really in a criminal jurisdiction. My lord, I am covered by one Supreme Court judgment and two High Court our High Court's judgment. Or is a criminal in nature, it has been said, when an investigation has been started.
So, Bandhupadhyay, what troubles me is whether the writ petition is maintainable or not is the writ.
That is a different issue.
Writ court who will decide it.
But now against that order,
An order is
passed where no appeal is maintainable.
Why not Article 15, the appeal is.
Latest, that is the point has been decided. Would your lordships can hear that? I can show the judgments and my lord, then, my lord, I will be personally happy if your lordships hold it. No, appeal is maintainable. Personally. But
Say the order is passed by a writ court.
by a writ court while exercised effectively in a criminal jurisdiction, criminal matters.
The point of maintainability is kept open.
Content of maintainability of the writ petition is kept open.
No distinction between a writ petition in a criminal side or
No, writ petition criminal side is maintainable. Against that order, any order, appeal is not maintainable. Latest patent appeal is not maintainable. Right. First, give it. Ramkrishna Fauji. First, your lordships kindly
My
see.
case will not cover.
No,
under Ramkrishna Fauji,
Mr.
I shall
Majumdar,
satisfy.
will you kindly every time all you will speak?
point the law point, he has the right to make such.
Yes,
Yes.
He will meet that
Yes.
argument. No
Give us the chances now. Earlier, we are not getting the chances. Now, give us the chances to say. Earlier, unfortunately, we are not getting any chances. Now we are getting chances to speak. No. This this has to be said. This is no. Now we are getting chances. Earlier, not. We were the other judge. No. First order that we have seen. None of them. You have not before your lordship's court. First, we will not prayer in the writ petition.
No, we are concerned with the appeal.
What is the nature of the writ petition? Lordships have to see. Then I will come. What is the nature of the writ petition? What is the relief has been asked sought for? Why patent? It is not maintainable, that I have to say. Lordships kindly come to the prayer of the writ petition at page 55. Running page 55. B. Issue writ or in the nature of mandamus, directing the respondents as their main and agents are assigned to SOCO as to why the investigational proceedings. Yes, in connection with the Bhatpara police station case number 70 should not be quashed with respect to the petitioner's hearing, and if no sufficient reason is shown to quash the same for the ends of justice. This is the main matter. Now, my lord, it is whether it is exercising the criminal jurisdiction or not, it could, that has to be looked into. My lord, kindly take this Ramkrishna, the Joseph judgment. Kindly take my lord Ramkrishna Fauji's case. This is my lord 2017 5 SCC page 533. First, lordships kindly come to paragraph 4. Paragraph 4, kindly come to paragraph 8. Questioning the sustainability of the order passed by the division bench, Dr. Rajiv Dhawan, Learned Civil Counsel, has a singular contention that the LPA before the division bench was not maintainable, inasmuch as the Learned Single Judge at paragraph 8.
Paragraph
8.
We were looking at paragraph 4.
Oh, all right. Paragraph 4, kindly come to paragraph 4.
Was not matching.
No. Kindly read the paragraph. At this stage, it is necessary to mention that the appellants had preferred civil writ petition number so and so, praying for a issue of a writ in the nature of statutory quashing of the impugned order dated 20th January 2014 and to 11th February to the passed by the respondent number 2. In short, by this order, directions for the criminal proceeding has been initiated. Then come to paragraph 8. Questioning the maintainability of the order passed by the division bench, Dr. Rajiv Dhawan, Learned Senior Counsel, has raised a singular contention that the LPA preferred before the division bench was not maintainable, inasmuch as the Learned Single Judge had exercised criminal jurisdiction. He has placed reliance on stance authorities to which we shall refer at the relevant places. Now, your lordships kindly come to paragraph 18. On a plain reading, lordship, you got it? On a plain reading of the aforesaid clause of the latest patent, it is manifest that no appeal lies against the order passed by the single judge in exercise of the criminal jurisdiction. Thus, the question that is required to be posed is whether the learned single judge, in the obtaining factual matrix, has exercised criminal jurisdiction or not. Then your lordships kindly come to 21. It is worthy to mention here that clause 10 of the latest patent established in Lahore High Court, which is applicable to the Honorable Punjab High Court, is perimeter with the clause 15 of later patents of the Chartered High Courts. The 4th judges bench is so and so. Now, my lord, kindly come to paragraph
paragraph, my lord, 29.
Yes.
After so stating, the court elucidated the nature of criminal proceeding, and in that regard rules that Ishwarlal Bhavan so and so. A criminal proceeding, on the other hand, is ordinarily one in which it is carried out to its conclusion. It may result in the imposition of sentences such as death, imprisonment, fine, forfeiture of property. It also includes proceeding in which is the largest interest of the state, orders to prevent apprehended breach of peace, orders to bind down persons who are a danger to the maintenance of peace and order, aimed at preventing vagrancy of the contest so and so. Explain then 30. The character of the proceeding in our judgment depends not upon the nature of the tribunal, which is investigated with the authority to grant relief, but upon the nature of the right violated and the appropriate relief which may be claimed. Then kindly come to paragraph 31. The aforesaid authorities makes a clear distinction between civil proceeding and criminal proceeding. As far as criminal proceeding is concerned, it clearly stipulates that criminal proceeding is ordinarily one which, if carries to its conclusion, may result in imposition of sentence, and it can take care with its ambit the larger interest of the state, orders to prevent apprehended breach of peace, and orders to bind down the persons who are a danger to the preventive of the court has ruled that the character of the proceeding does not depend upon the nature of the tribunal which is invested with authority, but upon the nature of the right violated and in the appropriate relief what may be claimed. Then, my lord, kindly come to this paragraph 32. 32, my lord, one paragraph has been quoted from one judgment, my lord, 92. Sorry, 92. The position which emerges from the above discussion is that under clause 15 of the latest patent of the Chartered High Court, from the judgment within the meaning of the term as used in that clause of a single judge of the High Court, an appeal lies to a division bench of that High Court, and there is no qualification or limitation as to the nature of the jurisdiction exercised by the single judge, which passing his judgment, provided an appeal is not barred by any statute, for example, 100 of the Code of Civil Procedure, and provided the condition laid down by clause 15 itself are fulfilled. The conditions prescribed by clause 15 in behalf of that is, it must be a judgment pursuant to section so and so, judgment so and so. Then 100. According to the full bench, even where clause 15 to apply, an appeal would be barred by the express words of clause 15, because the nature of the jurisdiction on article 226 and 227 is the same, inasmuch it consists of granting the same relief, namely scrutiny of the records and control of subordinate courts and tribunals, and therefore the exercise of the jurisdiction under these articles would be covered by the expression revisional jurisdiction and power of superintendents. We are afraid the full bench has misunderstood the scope and effect of the powers conferred by this article. These two articles stand on an entirely different footing. As made abundantly clear in the earlier part of this judgment, their sources and origin are different, and the models upon which their pattern are also different. Under Article 226 of the High Courts, including any have a power to issue directions, order under so and so for any person so and so. Article 226 of the High Court has power of superintendence over all courts and tribunals throughout the territory in relation to which it exercises jurisdiction. The power to issue writ is not the same as the power of superintendence by no so and so. Then will kindly come to paragraph 47. Dwelling upon the said issue, the court in Ganga so and so, wherein the court had categorized the certain aspects of the case as illustrations, wherein power under Article 226 or the inherent power under Section 482 CRPC can be exercised. We noted the court gave a note of caution to the effect that the power of coercing a criminal proceeding should be exercised very sparingly. So and so, this is not more relevant here. Kindly come to paragraph 51. It is worthy, my lord, got it? It is worthy to note that a series of decisions were cited on behalf of the appellants herein, including full bench judgment of the Gujarat High Court, Patel so and so, wherein the full bench considered Article 226 and 27 in the Constitution in the light of the various decisions of the court and deduced certain principles. The division which Sanjeev Kumar so and so distinguished this decision on the ground that full bench did not lay down as a proposition of law that LPS would be maintainable even if an order was passed by the learned single judge in exercise of the criminal justice so and so. 80. In our considered opinion, in the instant case, the proceeding can be said to be criminal proceeding, inasmuch as carried to its conclusion, they may result into imprisonment, fine, etc., as observed by the Supreme Court in Naran Rao case. From the totality of the facts, we have no hesitation in holding that a learned single judge has passed an order in exercise of criminal jurisdiction. At the cost of repetition, we reiterate that we have already stated earlier that the proceedings were of a criminal nature, whether a criminal court takes cognizance of an offense or stands compliant to so and so, and it does not make a difference so far as the nature of a proceeding is concerned. Even a cognizance is not taken. That fact would not take out the case from the purview of the criminal jurisdiction. In our judgment, a proceeding under Article 226 of the Constitution arising from an order passed or made by a court in service of the under the code is still a criminal proceeding with the meaning of clause 15 of the latest patent. A proceeding seeking to avoid the consequences of a criminal proceeding under the code of civil will continue to remain a criminal proceeding covered by the bracketed portion of clause 15 of the latest patent. Then will it kindly come to paragraph 52. From the aforesaid analysis, it is demonstrable that the Gujarat High Court has opined that relying upon the authorities of the issue whether proceeding are civil or not would depend upon the nature of the right violated and appropriate relief which might be claimed and not upon the nature of the tribunal which has been investigated to grant relief. The division bench further opined that if a cognizance is not taken in respect of a crime, it would not take out the case from the purview of the criminal jurisdiction. Thus, it has been held by the division bench that when there is a proceeding under Article 226 of the Constitution arising from an order whereby could issue power under the Code of Criminal, it would be a criminal proceeding within the meaning of the latest patent. Then will it kindly come to 56. As we find out from the decisions of the above three high courts, it is evident that there is no disagreement or conflict on the principles that if an appeal is barred under clause 10 or clause 15 of the latest patent, as the case has held that whether the power is exercised on Article 220 of the Constitution for quashing of a criminal proceeding, there is no exercise of the criminal jurisdiction. It has been distinguished proceeding for quashing of the FIR under 482, and that context has opined that from such an order, no appeal would lie. On the contrary, the high courts of Gujarat and Delhi, on the basis of the law laid down by the so and so, have laid emphasis on the seat of initiation of criminal proceeding. The consequences of a criminal proceeding are also the nature of the relief sought for before the single judge under so and so. The conception of the criminal jurisdiction, as used in clause 10 of the latest patent, is not to be construed in the narrow sense. It encompasses in its gamut that inception and the consequences. It is the field in respect of which the jurisdiction is exercised is relevant. The contention that solely because a writ petition is filed to quash an investigation, it would have a room for intra-court appeal, and if a petition is filed under such inherent use under Article 42C, there will be no scope for intra-court appeal, would create an anomalous, unacceptable, and inconvenient situation. The provisions contained in the latest patent does not allow or permit such an interpretation. When we are required to consider a bar or non-permissibility, we have to appreciate the same in true letter and spirit. It confers jurisdiction as regards the subject of the controversy or nature of proceeding, and that subject is exercise of jurisdiction in criminal nature. It has nothing to do whether the order has been passed in exercise of the extraordinary jurisdiction under Article 220 of the Constitution or inherent jurisdiction of under Article Section 482. For this regard, an example can be held in similar in 58. In view of the aforesaid premises reason, we hold that the High Courts of Gujarat, Delhi have correctly laid down the law, and the views expressed by the full bench of the High Court of Andhra Pradesh is incorrect. Then will kindly come to paragraph 60. On the aforesaid basis, the division bench in the proceeding on Article 2 consisting of civil rights, the proceedings are civil in nature, falling within the ambit of clause 10 of the latest patent. In said case, the detention was under the copy pusa. The court observed that the said detention is purely preventive without any trial in a criminal court, and the challenge to such detection is for the enforcement of the civil right, fundamental, and therefore read under Article 2 for issue of a so and so has been a this is the distinguishing point. Then kindly come to paragraph 62. In view of the aforesaid premises, prismatic reasoning, the irresistible conclusion is that the latest patent appeal was not maintainable before the division bench. Consequently, the order passed therein is wholly unsustainable, and accordingly it is set aside. However, as the state had been diligently agitating its grievance in a legal forum, which is thought jurisdiction, we grant liberty to state to avail the order of the learned single judge so and so. Now, my lord, next, there are two judgments of our high courts. First one is that, my lord, citation বলে দাও। My lord, 2020 SCC online Calcutta 755 division bench judgment presided over by the Chief Justice, the then Chief Justice. Let's straightway come to paragraph 21. Having considered the aforesaid three decisions and several other decisions, the Honorable Supreme Court held that High Court of Gujarat and Delhi have correctly laid down the law, and the view expressed by the full bench of the Andhra Pradesh High Court is incorrect. The Honorable Court also observed that the conception of criminal jurisdiction as used in clause 10, which is parameter with clause 15 of the latest patent, is not to be construed in a narrow sense. It is not this practically quoting from that judgment, paragraph 22. The facts of the case of Ramkishan Fuji are different from the facts in the present case. In that case, the learned single judge order had consequence which was clearly criminal in nature. The learned single judge opined that the recommendation of the lockout of registration of Ramkishan Fuji's case. Now, kindly come to
Reading.
reading the. Well, kindly, yes. Well, just few lines, kindly skip. First, second, third, fourth, fifth, sixth, seventh, eighth, ninth, 10th, 11th, 12th. 12th line from the bottom of that paragraph. Reading the Honorable Supreme Court decision in the case of Ramkishan Fuji as a whole, we cannot accept the contention of the learned senior counsel representing Gopal that if the High Court in exercise of the power under Article 2 of the Constitution passes an order which has even the remotest connection with a criminal case, then the order must be said to have been passed in exercise of a criminal jurisdiction, notwithstanding that the order by itself does not have any criminal consequences in the sense that it neither directs initiation of a criminal proceeding, which may have penal consequences for the accused person, nor it directs quashing of the termination of a criminal proceeding, thereby relieving the accused person causes so and so criminal, thereby relieving the accused person of possible penal consequences. In our concept, the decision of the round does not advance the case of the writ petitioner on the point of maintainability of the appeals. Then, Miller, the other paragraphs have been quoted. Then kindly come to paragraph. Paragraph 27. We have no disagreement with the proposition of law propounded in the aforesaid. However, in the facts of the present case, learned senior neither resulted in initiation of the criminal proceeding nor in quashing of the criminal proceeding. The facts of the incident are different. Here, the criminal proceeding is in question. Now, Miller, kindly come to another. They are paid for quashing of the proceeding. Now, my lord, kindly come to another judgment. That's, my lord, my learned friend appeared in that matter. All we preferred appeal, including states, in Shubhendu Adhikari's matter. That is, my lord, it's short for, my lord, the quashing of the criminal proceeding. And there, my lord, the interim orders were passed. Number of persons, including state of West Bengal, also preferred an appeal against that order. Lordship got it, my lord? That kindly come, I will not take much time to your lordship to finally read this paragraph, my lord. Last page 16, kindly come. All the judgments have been considered, my lord. In that case, challenge was quashing of the criminal proceedings. Interim orders were passed. We, state of West Bengal, preferred appeal. State of West Bengal preferred an appeal, right? State of West Bengal preferred an appeal. That appeal has been dismissed on the ground that no, latest patent appeal is not maintainable. There was for the state of West Bengal, we want to know, what is the law then? In one case, when I will come, not maintainable. When he will come, it is maintainable. It cannot be the law. Therefore, it is not maintainable. Held it, that the primary reliefs granted by the Honorable Single Judge pertain to the exercise of criminal.
Case of this Gopal Kumar Agarwal, it was said as maintainable.
Yes, because it was transferred.
Because it was a transfer of investigation. If a transfer of investigation is there, it is maintainable. Not initiation or quashing.
And what has been held here?
In Shubhendu Adhikari's case, they sought for quashing of the criminal proceeding. They got an interim order. Against the interim order, private persons and the state of West Bengal also preferred an appeal. Then this division bench of the Calcutta High Court has held, no, it is not maintainable. Similar, last A, that the primary reliefs.
According to because the clause 15 of the letters patent says that an appeal would lie against a judgment, provided it is not passed by a criminal
Jurisdiction.
Criminal jurisdiction. So if you say that criminal jurisdiction means even if the writ is filed, but the object and the purpose has to be seen, and if the primary relief which is claimed is the quashing of an FIR, then in that event it is really an exercising the criminal
Jurisdiction
under the writ jurisdiction, and therefore embargo is created under clause 15 of the letters patent.
Latest
Appeal is
patent.
not patent.
But after this Rampauji's judgment, but I will be personally happy, I tell you, lordships, if your lordships hold it to maintainable. But because of these judgments also.
Yes, my lord, it's a my lord, distinguished feature in our case. My lord, in our case, your lordship will see the prayer. Petition number 1, she is not an accused. We did not pray for termination of the proceeding or initiation of the proceeding.
You ask for a quashing of the
No, quashing of the investigation proceeding where my right under Article 21 has been infringed.
quashing of the
Investigational proceeding, my lord. I have never prayed for proceeding. Kindly see the distinguished, my lord.
why the investigation?
Yes, because I have been given a notice under section 160. 160, your lordship knows better than me. It's a notice given to a witness. We have challenged that notice before this court, my lord. And that is the way, my lord, that I am saying, my lord, it is infringement of fundamental right under Article 21, which is a civil consequence. That is the reason this, my lord, the appeal is maintainable. I shall, my lord, place one by one. I shall distinguish all these judgment and place, my lord, the relevant facts of this case. Your lordship will understand how the malafide investigation is going on in respect of the petitioners only. My lord, I am not praying for quashment of the entire FIR or entire charge sheet. I am saying the investigation, so far as the present petitioner is concerned, it is bias and malafide. And section 160 notice is bias, the outcome of biasness and malafide, my lord. That is my submission, and that has a civil consequence under Article 21 of the Constitution. This is my submission. I shall satisfy your lordship. If I place the facts of the case, your lordship will be, my lord, everything will be clear. May I, if your lordship, my lord, permits me, I can place it also now.
First thing is you will have to make a distinguishing.
Yes, I can. My lord, I can. My lord, kindly see. My lord, our case is completely different. Completely different. Here, my lord, I have not prayed for quashing of a, my lord, proceeding or FIR or charge sheet. My lord, I said in my application, the proceeding qua the petitioners. It's malafide and it is infringement for violation of Article 21, which has civil consequence. The same principle has been reiterated in Ramkushan Fauji's case also. Gopal Agarwal also, it was a habeas corpus application where there is illegal detention, infringement of Article 21. Their lordship has held this application, the writ is maintainable. But I shall argue on that line only.
Yes. You will argue or your senior will argue?
Lord, if he is not available, I shall argue. I have no difficulty, I am ready with the matter. But he was waiting, my lord. I kept him waiting. Now, my lord, somehow the matter could not be taken up.
Tomorrow I have difficulty.
I am ready.
I have cancelled my program since yesterday. They have taken time. Today, yesterday I was. Tomorrow, day after tomorrow. I don't mind.
Till both of you ends.
But I am ready. My flight is 6:45.
That is what I am saying.
My flight
is already there.
My flight, and in the night, the last day I was arguing a matter.
Friday we can keep.
Yes. For this, no, please. For this matter, because since it was yesterday, I came day day before yesterday night at 3 a.m. in Calcutta.
At 3,
But
my
they
lord,
had taken time, I have
at
said.
2, I have some difficulty. If you can keep it at 3, my lord, I can.
3 I have matters, my lord. In the morning, then 3.
Morning, I have no difficulty.
My lord, 3 p.m. my matters. Part
Morning,
of
I have no difficulty.
Friday. 3 সময় আমার মামলা প্রায় ফিক্সড আছে। Any problem? Lord, take this matter on Saturday.
Problem is not with me. Problem is
Of course,
my brother has to go to NJ.
Oh, my lord will come back.
Is although
My lord will
there, all the programs in
Saturday, Friday when
Judicial Academy.
Friday is problem.
Is from Friday, Saturday, and Sunday.
Whole day will be there.
National Judicial Academy.
And that will be at National Judicial Academy.
National Judicial Academy is Bhopal. Not here.
MP.
Otherwise, your lordship has to leave tomorrow.
Monday, Tuesday, my lord, Monday, my lord, I have some personal difficulty.
No,
Tuesday.
from
Any time your
25th,
lordship will.
from 25th, I am having this session. Then in that case, make it a Friday week. I will come back tonight.
Monday, what difficult?
My session will start. My parliament session.
Monday.
Anyway, my lord, I will skip one day from the parliament. I can come on Friday, my lord. In the midst of the week, it's difficult. 25th, I have to go.
What Friday then?
I have no problem. I have no problem.
Which time is convenient to both?
Friday.
Coming Friday week, sir.
Friday week, you will also fix it any time. I am.
My brother is not there.
No, it's all right. Anytime. Anytime.
Anytime.
Anytime.
They have to come back. That's why.
I will come back on Thursday night. ভাই আমি কিন্তু পারবো না আর করতে তাহলে তুমি যেভাবে ইচ্ছে টাইম না দেখলাম কোনো অসুবিধা নেই। আমি পারবো।
Because I do not want to disturb the other in the morning at 10:30 first matter.
Yes.
On Friday week.
On Friday.
Flood protection maybe will not continue.
That he has assured, then I believe that nothing will happen.
No, I simply because Justice Bhattacharya will go to for some discharging for other function. My lord, leave it to me.
As your lordship.
I can understand, my lord, the difficulties of the honorable judges. My lord, it's not that.
Otherwise, we could have kept this matter even tomorrow. Or
Lord, tomorrow.
We are also ready.
Lord,
Either
that
myself or Mr. Jagdish.
I have the most important that the leave it to me. I will. Just when my lord, my lord is having a real difficulties. We have to.